See, I am ready. I am ready to start my presentation. Is that all right?
Yes.
Yes.
Good morning, everybody. So we will officially start. I'm glad you were able to solve that, Laura. And just let me know, would you like me to share your presentation so that you don't have, and then you just tell me when to go from slide to slide?
No, he does. He does it. Oh, you don't. He can do it. Yeah, you can do it. Okay, we're in, and you can do it. All right. So may I start?
1 second. Let me get your presentation up. Okay, go ahead and start, Laura.
There you have it. All right. The recovery of human rights. Start with the introduction. Human rights can be conceived more broadly as tools for an all-around protection of a dignified life, with the basic aim to empower the powerless within an oppressive power structure. And of course, you are going to have to read as much of the notes as you can. I don't have time to wax eloquent on the notes. This is a chapter of a book, of course, that's already published. That's why I will not take space from other people in our publication for this. This chapter will explore various theories.
Please, everybody mute.
Please, let me speak. This chapter will explore various theories as they develop through history, and which specifically may be viewed as precursors of Nowak's position, reference above. Costas Cousina's work provides a fascinating journey through the history of human rights in his 2000 book, The End of Human Rights. A new idea has trumped in the global world stage, human rights. It unifies the left and the right, the pulpit and the stage, the minister and the rebel, the developing world and the liberals of Hampstead and Manhattan. Human rights have become the principle of liberation from oppression and domination, the alluring cry of the homeless and the dispossessed, and the political cry of the homeless and dispossessed, and the political program of revolutionaries. So a whole a number of different and special connections can be traced, and they're all based on the end of human rights, as Costas Cousines suggests. He believes that the myth that history moving on as a single unified process towards the aim of human liberation is not correct. He thinks the important point is Antigone's understanding of unwritten laws in opposition to purely human ones, and developing steadily through centuries to underlie the important work of the Spanish Dominican school, the work of Francisco de Vitoria and Bartolomé de las Casas, and that gave us the foundations of international law. References are there, but of course, I cannot give them to you. Natural law is the basis here, and the natural law was not only what I have spoken of before, but it's also to be seen in the work of Hobbes. It's not sufficient to look at Aristotle or even Aquinas. Best look at Martin Luther King Jr. A just law is a man-made code that squares with the moral law or the law of God. An unjust law is a code that is out of harmony with the moral law. To put it in terms of St. Thomas Aquinas, an unjust law is a human law that is not rooted in eternal law and natural law. Any law that uplifts human personality is just. Any law that degrades human personality is unjust. And that's Martin Luther King, which I am sure you are familiar with. The ideal of liberty of the individual reemerges as his power to choose to do right and wrong, and these choices justify human dignity, not just preferences, and can be judged according to the principle of immutable law. That law can and should be justly adapted according to different times. Basic figures such as Hobbes and perhaps Locke need to be cited. Hobbes is particularly relevant. The right of nature, which rights commonly jus naturale, is the liberty each man has. By liberty is understood, according to proper signification of the word, the absence of external impediment, which impediments may often take away the part of man's power to do what he would. The law of nature, lex naturalis, is a precept or general rule found out to be reason by which a man is forbidden to do that which is destructive of his life, and so on. We ought to speak about this subject because right and law ought to be distinguished, because right consisted in liberty, whereas law determined and binders to one of them. In criminal law, all those who participate in the commission of a crime, and notice that we are going to be speaking about crimes here, because before we finish, we will see why crimes are being committed in today's world. In criminal law, all those who participate are taken to be guilty, albeit in various degrees, to be assessed at the time of sentencing. They range from those who plan, those who benefit in various ways, those who contribute in any way to the commission of crimes. They are called concurrent causes. Hart and Honoré provide the suggestion. When joint or several tortfeasors have contributed to the same harm, the obvious rule is that each should be liable for the whole harm. In environmental cases, this is obvious. Well, we try to look at the most proximate cause, but the proximate cause is a convenience, not a natural reality. On the question of causation, Hart and Honoré argue that the three questions one needs to ask in order to recognize what constitutes the harm is whether the defendant was under the duty of care, whether he was in a legal sense guilty of negligence to the plaintiff, and whether his action was the proximate cause of the injury. The one question the author suggests, citing Denning, who says the simple is better, is the consequence within the risk? So being fully aware of the risks pushes a further question: are they relevant whenever causing, inducing, helping, encouraging, or permitting? May I go on? Others to act is a sufficient ground for criminal responsibility. The direct effects of lead, for instance, is a case in point. As early as 1924 in Germany and 1978, the use of lead pipes for water were discontinued in those countries. In North America, the discovery of methylmercury formation went unnoticed until Norva Schimreiter, a Norwegian graduate student from the University of Western Ontario, started analyzing fish for mercury. Now, these Ontario waterways include some First Nation people's ancient fishing districts. The Ojibwe inhabitants of Grassy Narrows, the reserve, depend on local fish as a staple, and many men earned a living as fishing guides. When the factories upstream leached mercury, and this is a problem that today in 2021 has still not been solved, by the way. You can see it as they protest at City Hall still. The band of Chief Simon Fobister said in 1978, "We are now a people with a broken culture." As Theo Colborn explained as far back as 1996, when her land work was published, endocrine disruptors being the cause of the exponential increase of autistic children in the last few decades, as well as the same unexplained increase in the number of cases of ADHD. Finally, EDCs are also gender benders, as can be assisted by studying, as Colborn and other fellow scientists did, the wildlife in Canadian St. Lawrence River, home of gay gulls and hermaphrodite whales. Beyond animals and toxicology, later in 2013, two foundationally important works were published by Oxford. Both are extremely relevant to our topic. They explain why we need to recover human rights. They are Philippe Grandjean's only one chance to develop a brain. And Philippe Landrigan and Ruth Etzel, textbook children on environmental health. Please make note of these two works, because they are absolutely foundational to what we're trying to do. However, it's normally states that are the ones that deal with human rights. They seem to have the right and the duty to take care of human rights. However, the law normally claims legitimate authority not merely as a claim that legal rules are reasons. It includes the claim that they are exclusionary reasons and or disregarding reasons for non-conformity. The main question raised in this chapter is who or what has the power to protect human rights? And the answer is a single one. Rulers, only as they are the only power who controls the dispensing of justice, hence the law. The authority of law is theirs alone. It is limited only, as Raz indicates, but the respect due to the free will of individual. We can cite the Magna Carta, but that is primarily a document intended to protect noblemen from a sovereign. It's the Charter of the Forest instead, clearly a document intended to protect the most basic right of common people. The Charter of the Forest was first issued on November 6, 1217, as a complementary charter to the Magna Carta, from which it evolved. It was reissued in 1225, with a number of minor changes in the wording. And then it was joined to the Magna Carta in the confirmation of charters in 1297. In contrast to the Magna Carta, which dealt with the rights of barons, it provides some real rights, privileges, and protections for the common man against the abuses of the encroaching aristocracy. The Forest Charter is without doubt the first ecological charter in history, but it is more than an environmental regulatory regime. It is also the first document that grants liberties to the common man. The Magna Carta was a document forced upon King John III by the nobles and barons of the time. After John's death in 1216, in 1217, Henry III reaffirmed it through his advisors. He was only 9 years old when he inherited the title. And it was Henry III who proclaimed the Charter of the Forest. So you can read more on the Charter of the Forest, but I want to concentrate on the fact that it is without doubt the first ecological charter in history, but it is more than an environmental regulatory regime. It is also the first document that grants liberties to the common man. The Magna Carta was a document forced upon John III, but it is the other document, the environmental one, that is the one we need to follow. Now, the growth of neoliberal globalization was the proverbial final straw that we saw, as well as the environmental hazard with which we are familiar. The unchecked presence of commercial enterprises and trade meant that a tropical disease could not have traveled so far and so quickly as COVID-19, or more accurately SARS-CoV-2, could not have spread as easily and quickly as it did. In fact, the person to follow, we will see, is somebody who actually predicted what happened as early as 2012. Coronaviruses have been widely identified in Guangdong, China, and several such diseases existed long before we became aware of it. The present outbreak, SARS-CoV-2, is also a zoonotic disease, which appears to be transmitted by wet markets or originating from bats. as well. Strains from humans are phylogenetically related to those from bats, although current public health does not discuss the zoonotic sources of the present pandemic. They just rely entirely on the presence of vaccinations, which unfortunately are not enough. One Health was was the only source of information about the growing and quickly emerging problem of animal-related viruses, zoonoses, in 2012. However, David Quammen published a work called Spillover, and he talks about all the, you can read for yourself, the different diseases that long before we were aware of it, were simply happening. He explains what is happening to generate all viruses outbreaks that are cited here, many of which are unfamiliar to most of people. He cited the three elements in the situations. One, mankind's activities are causing disintegration, a word chosen carefully, of natural ecosystems at a cataclysmic rate. We all know the rough outlines of that program. By way of logging, road building, slash and burn agriculture, hunting, eating of wild animals, when Africans do what we call bushmeat, and impute a negative onus, though in America it's merely called game, clearing forests to create cattle pasture, etc., etc. So all the various activities that we tend to follow are entirely such that they facilitate the growth of the problem. But there is something else. It's not only the states that actually have the responsibility for this. Those who have the most responsibility are actually the corporations. And the relationship with the citizenship became a matter of getting the best terms out of the employment contracts. The citizens' human rights were government's responsibility, not theirs. In short, the race to the bottom was on, as Stephen Ratner speaks of corporations. States, as we have argued, have failed both to protect in domestic and international law to protect human rights. And the ones that have substituted states essentially are the corporations that have the power. So this meteoric race is particularly amazing. In Canada, we had one corporation with a royal charter who at least had some kind of connection to the land, and it was called the Hudson's Bay Company. We still have it today, and still today has some kind of connection to the people. But at that time, it was a corporation thriving as a single-purpose organization, fulfilling a need, special hats, but not actually doing anything else more important. Most significantly, all of this happened from the case that I have termed the original sin. And you can see for yourself that what the original sin was. Mr. Chief Justice Waite said, the court does not wish to hear arguments to the question of whether the provision of the 14th Amendment of the Constitution, US of course, which forbids a state to deny any person within its jurisdiction equal protection of the law, applies to these corporations. We are of the opinions that it does. So this banal US decision has been widely recognized as the first step in the ongoing assumption of parity in natural and legal person, which was really the main problem that we have encountered. Okay. I am going to just let you take a look at this, but I just want to skip because I'm late, as you know, and I don't want to take too much time. We are only on slide 16. Anyway, other forms of transnational organized crime were already being prosecuted. You can see the references. In fact, we find those in the mafia. Mafia in Italy, in its various manifestations, whether it appears as 'ndrangheta, Camorra, Cosa Nostra, or simply as a family clan, has been acknowledged as a transnational crime for a long time. So we have transnational crimes existing for a long time. And I am going to just let you quickly take a look at the real source of power and the office of the prosecutor that decided to seek more important ways of connecting with the people. The 2016 document from the Office of the Prosecutor appears to fit well within the general guidelines of the strategic plan that they had, as well as fitting within the increasingly wide social reach of the most recent UN-sponsored documents. Such as those that deal with non-state actors. So we come now to the question, states have not done their job. Corporations and mafia institutions seems to have taken their place. It's particularly interesting, however, to read Philip Alston, 2006, Not a Cat Syndrome, regarding human rights. He says, when one of my daughters was 18 months old, she deftly transcended her linguistic limitations by describing a rabbit, a mouse, or a kangaroo as not a cat. In the areas of international law and human rights, an almost identical theory is pervasive. But in order to protect human rights, Alston states, it is vital to understand the relation between different actors that are involved. And the first step is to understand exactly what is the nature of such actors before we can discuss how they evolved to the point of acquiring the power that they presently wield. We need to discover who should be accountable for the many human rights breaches, since the failed state obviously is not. So non-state actors are the ones that seem to have acquired a power totally unrelated to what they originated from. For instance, in the US, in Iraq, there are a number of contractors working as civilian security guards, agreed to be between 15,000 and 20,000, and they do everything. They handle military logistics, etc., etc. Some of that militia were translated as interrogators. Eventually, the world learned all about the Abu Ghraib prison and the torture imposed on the inmates. These were simply mercenaries who claimed the authority to set up checkpoints, detain people, confiscate cars with impunity. The human rights violations that followed should have been responsible of the state that employed them, but that was not the case. Okay, we're coming to the end now. We have been trying to define non-state actors of various kinds, with the emphasis on the significant harms they cause to human rights. The latter are clearly based on racist premises that those harmed were not worthy of consideration, especially poor, non-white, indigenous to the affected areas. There's yet another area, another activity that characterizes them, particularly a segment we need to discuss in detail with the INGOs, because certainly confirm the ubiquitous presence, moving in and out of position they might occupy in a situation that involves a state and its legal apparatus at one time, perhaps more often a situation that involves international legal regimes. INGOs are members that can be highly respected, such as Amnesty International, Greenpeace, Doctors Without Borders. Others are far less admirable. Some of them matter anyway, admirable or no. Mattering, so it seems, says Matt Nordman, is a socio-political rather than legally significant. It is for international law rather than in international law. So they are relevant in various ways, although they are not firmly established in international law. We cannot claim that INGOs are subject to international law. In fact, their participation in global affairs is undeniable. An International Court of Justice has stated that legal status reflects the needs of the global community. You can see the references there. While many international agreements come into being through the activities of NGOs, lobbying, agenda setting, consultancy, etc., NGOs have never played a role formal in the conclusion of treaties, but they are there and they are quite important. So we will conclude by saying that every stand of information, every set of circumstances we have followed could be used to protect human rights that are on attack today, as they have been for the last several decades. They have led us to an area inhabited by those who are determined to evade responsibility, the area of supranationalism. It's an area that includes several novel legal efforts to involve regimes and institutions that have not been previously tried. These extreme circumstances serve to disclose those that must be held accountable for engendering and development of both disasters, as we consider both disasters. I'm talking about the pandemics, of course, and more than the immediate causality we have been forced to consider as sufficient. It is the non-state actors we have seen described variously as MNCs and MNEs that are the true source of financial power. That's where the financial power is, in the corporation, evading all controls by deliberately operating beyond established legality. They seem to operate at a level, you can say above, below, but anyway, separately from both national and international law. Of course, we can continue to hope that the law itself will develop in line with Antonio Cassez's felicitous expression, as he reminds us that international law is presently still rudimentary, and that its potentiality has not fully developed. But while we wait for that happy thing to happen, and for law to become stronger, what we should do is to forcefully demand that the most basic rights for whose protection we have argued in these pages be quickly added to the classic core rights, so that we can reclaim supranationalism and evict once and for all the corporate criminals that have been occupying that space. Thank you, and I apologize for overstating my time.
Thank you so much, Laura. And I was just going to congratulate you for actually staying within time, because we did start a bit late, but you did your talk within 30 minutes. Maybe a couple of questions. I was wondering quickly,
Yes.
if you could just, we have these emerging things like rights of nature, which are in some sense a counterbalance to the recognition of corporations as legal persons. Now recognizing nature or rivers as legal persons. There's that, and also the addition of ecocide potentially to the treaty. I forget which treaty is, but recognizing ecocide as a crime, a new crime. I was wondering how you see those developments as relating to your really excellent analysis there.
Well, I think they are important developments, no doubt. But as far as I'm concerned, I want to see how the human rights have developed and what hope is there for us to regain them, aside from other development that Klaus and you have so well put forth in your presentations.
Great, thank you. And let me just look at the chat. If let me just turn to Rose, who had a question, and then we'll have to move on to our next presentation.
Yeah. Okay. Well, actually, I found that my presentation very interesting. And when you refer to the Magna Carta and is it the Charter of the Forest? I'm just wondering if you're familiar with a proposal or some sort of an organization that Prince Charles in England has started. He gave a presentation that I happened to be logged on to a webinar that was sponsored by, I think, Foreign Policy, a journal in the U.S. And he started something called the Terra Carta, which is modeled after the Magna Carta. And it occurred to me that that sounded much like the Charter of the Forest that you were talking about.
That sounds interesting, Rose. Thank you for your idea. Worth pursuing.
Yeah, it sounds like maybe a presentation for another GEIG meeting. So we are going to have to move on now. So I will turn now to Giada Giacomini. And Iman, I can't see the other name.
Okay, we are here. We're ready.
And Emanuele Frato Rossi Gripaudo. Yeah, great. So take it away. You're going to share. Are you going to share your screen?
Yeah, we're going to.
Okay,
so we're going to do this. Thank you so much.
Go ahead, sit up, and I'll give you a 5-minute notice.
Sure. Good morning, good afternoon, good evening, depending on where you are located. My name is Giada Giacomini. For those who know me already, who don't know me already, sorry. My areas of expertise are climate justice, indigenous people's rights, and critical legal studies applied to human rights-based approaches to climate change.
Good morning, good afternoon, good evening, everybody. My name is Emanuele Rossi Gripaudo. I am an Italian PhD in public law and a lawyer. My area of expertise is administrative law, in particular topics concerning the Court of Auditors and environmental law. I am attending this conference with great pleasure, and I hope to make a useful contribution to your cause.
I'm going to share our presentation for today. Can you see it full screen?
Yes, it looks great. Go ahead.
Yeah, is that, sorry, my computer was muted. Okay, so basically, before presenting, I would like to explain why we are working together with this, because we come from two different backgrounds. So basically, the reason why we are working together, because we wanted to study how the right to health environment is developed in Italy. But in our country, environmental law is a very technical subject. So we decided to join efforts, and we started working together on this topic. So today we're going to present about the right to health environment with Italy as a case study, and with some critical legal perspective regarding the anthropocentric approach of the right to health environment, and we will conclude with the right of ecological integrity. So this is the overview of the things that we're going to talk you through today. So we will start with the right to health environment in Italy. And then we will say something about the right to health environment in the inter-American system, because it's a bit different from our Western conception. And then we're going to apply a bit of critical legal thinking to human rights-based approaches to climate change. And we'll conclude with the right of ecological integrity. Before starting, we just wanted to make sure that everybody's on the same page. So basically, the right to health environment, when applied, it prescribes that everyone has the right to an adequate environment. And an adequate environment is actually considered like a modification of other fundamental human rights, such as the right to life, the right to food, and the right to health. But this right to health environment has somewhat evolved as something different, and we're going to tell you more about this. So I leave the floor to Emanuele.
Thank you, Gianna.
You can start.
Okay. So I'm going to examine the role the right to a healthy environment plays in Italy in the following order. First of all, I will examine which sources of law govern the right to a healthy environment in Italy. Second, I will examine the characteristics of the Italian right to a healthy environment. Third, I will examine the judicial protection given by Italy to the right to a healthy environment. And last, I will examine some future prospects for the right to a healthy environment in Italy. So, the first question we should ask ourselves is, which sources of law govern the right to a healthy environment in Italy? The 2019 report of the Special Rapporteur on the issue of human rights obligations relating to the enjoyment of a safe, clean, healthy, and sustainable environment states that the Italian Constitution only gives an implicit recognition to the right to a healthy environment. This is true. Indeed, the Italian Constitution does not directly recognize the right of every individual to live in a healthy environment. The Italian Constitution does not even directly guarantee the protection of the environment. It only guarantees in Article 9 the protection of the landscape and its natural beauties, and in Article 117 establishes that if an environmental protection law is needed, the state is the only competent authority to enact it. This shortcoming is due to the historical context in which the Italian Constitution was written. The Italian Constitution was written between 1946 and 1948, and in 1946, Italy had just emerged from a 20-year dictatorship and a world war. So the constituent legislators were primarily concerned with introducing into the constitution rules that guaranteed the primacy of democracy and the protection of human rights and fundamental freedoms. In this way, they overshadowed other goals related to individual well-being, such as the right to a healthy environment. Furthermore, the country was characterized by a limited urbanization, a poor industrialization, and a predominantly agricultural economy. Therefore, there were no significant environmental issues. Last, the preparatory work of the Constitution highlights how in that historic period, Italian legal doctrine considered the environment as a synonym of the landscape and its natural beauties. So not as something to be autonomously protected. As I said before, natural beauties are considered part of the national heritage, and their conservation is guaranteed in Article 9 of the Constitution. The 2019 report also states that the right to a healthy environment is not even guaranteed by any Italian legislative act. This is also true. Therefore, it is possible to argue that this right was introduced in the Italian legal system by the national courts, in particular by the Court of Cassation. The Court of Cassation is the highest court of appeal in Italy and ensures the uniform interpretation of the law. In a groundbreaking ruling issued in 1979, this court stated that the right to health, which is guaranteed by Article 32 of the Constitution, must be interpreted in an extensive way, including not only the mere right to life and to physical or psychical safety, but also the right to a healthy environment. In Italy, the right to a healthy environment is the right of every individual to live and develop personality in a natural or artificial context in which nothing constitutes a danger to physical and mental health. Let us move on to the characteristics of the right to a healthy environment. The right to a healthy environment is an individual right entitled only to natural persons. Legal persons cannot suffer any damage to health, therefore they cannot have a right to a healthy environment. Second, as all the others fundamental human rights, the right to a healthy environment is an absolute, untransmissible, and irrevocable right. Third, the right to a healthy environment is an innate right, which is acquired by birth. Let's talk about the justiciability given by Italy to the right to a healthy environment. In Italy, any person who suffers an infringement of his right to live in a healthy environment may seek compensation for the damage suffered in front of a court. In order to obtain compensation for the damage suffered, the plaintiff must prove in court the existence of the following elements. First, the plaintiff must prove having suffered a damage to their health due to an unhealthy environment. Second, the plaintiff must prove that the unhealthiness of the environment that damaged them is due to the other party's willful or negligent conduct. In the same way, any person who is endangered by polluted natural elements may ask to court the adoption of an order which inhibits the activity that makes the environment unhealthy. Let us see some future prospects for the right to a healthy environment in Italy. First, let's make a distinction between the right of a single person to live in a healthy environment, which is a human right and can be exercised by the individual, and the interest of a community of people to protect the environment, which can be directly achieved only through the role of the state. Indeed, the newly renamed Ministry of Ecological Transition is entitled to ask those responsible for environmental damage to compensate for the damage. Environmental associations can only intervene and not start the process for environmental damage. And these associations can also request an administrative court to annul administrative measures which affect the environment, such as a building permit or an act which establishes the geographical position of a new production plant. So, regarding the future prospects for environmental protection in Italy, over the last 20 years, Italian decision makers have sought to introduce the protection of the environment into the Constitution. The article chosen to host this new fundamental value is Article 9, which protects the landscape. Explicit recognition in the Constitution of an autonomous interest in the protection of the environment is desirable, especially if the term environment is accompanied by that of ecosystem. And let us move to the future prospects for the right to a healthy environment in Italy. At the moment, there are no incoming reforms aiming to introduce the right to a healthy environment in the constitutional text, nor in the environmental legislation. So what can I say? A reform of the Constitution in this respect is obviously desirable. Thanks for your attention. Back to you, Giada.
Thank you. Okay, so I think that we can move to some international perspectives. So I would like you to consider how the right to healthy environment is developed in the American system and how this can be different from our westernized perspective on the right to healthy environment. The regional human rights instruments of the American system did not recognize the right to healthy environment. But with the adoption of the San Salvador Protocol in 1985, the environment was considered a human rights subject. Of course, the right to healthy environment is especially developed at the national level, but this regional instrument is very important. The statement of the San Salvador Protocol regarding the right to healthy environment, as you can see, is quite broad. However, the Inter-American system is really particular because also thanks to the Inter-American Commission, to the Inter-American Court of Human Rights, we can see that in the Inter-American system, especially in South America, the right to healthy environment is a collective right, so it's not an individual right, and this collective dimension is very important because it also recognizes the special interlink, special connection that vulnerable communities such as indigenous people have with their environment. In fact, if we consider the Declaration on the Rights of Indigenous People adopted in 2016 by the Organization of the American States, we can clearly see that there is a provision especially dedicated to the right to the protection of a healthy environment. This article establishes that indigenous peoples have the right to live in harmony with nature and to a healthy, safe, and sustainable environment. It also establishes that indigenous peoples have the right to conserve, restore, and protect the environment and also to manage their lands. And most importantly, when we talk about indigenous peoples and the environment, we are talking about also their history of colonization and all the tremendous things that happened in the past centuries. So this article tells us that indigenous peoples have the right to be protected against the introduction, abandonment, dispersion, transit, indiscriminate use, or deposit of any harmful substance. And finally, that indigenous peoples have the right to the conservation and protection of the environment. And I think that this aspect is somewhat connected to the Convention on Biological Diversity and to the Nagoya Protocol. However, now I would like if we all take a step back about human rights. Because I think that it's important not to take anything for granted and to understand through critical legal approaches what are human rights. This is important because in some ways human rights bear in themselves the limits to their same application. Now I will explain to you what I intend with this. So we need to ask ourselves which human beings protect human rights. Well, my assumption, which is based on the studies of important critical legal scholars like Upendra Baxi and Anna Greer, is that the abstract human that human rights are protecting is not so universal as we are used to study and to use in our research. So the question is, whose struggles have been given voice to the rhetoric of recognition of human rights? Well, as you all know, human rights were firstly conceived in moral philosophy and not in law. The prevailing philosophical underpinnings behind human rights have remained unaltered since the 17th century. Such rights are conceived to be linked to all human beings, and they also constitute a deontic postulate upon which whole human rights law is based. This aspect can be considered challenging. Why? Because human rights are based on a westernized conceptual law. The westernized conceptual law traditionally has divided body and soul, human and nature, and masculine from feminine. And this dualistic division is also inherent to human rights law that tends to separate the human being from the environment and to consider the human being superior to the environment and to the animals and to the other manifestations of life. Furthermore, human rights, they are inherent to the different philosophies and societies and cultural expressions. And this is particularly true because we can see that, for example, the right to healthy environment is considered differently in Latin American context compared to Italy, which is a Western country, for instance. And the other important point is that we have seen a proliferation of human rights instruments from the Declaration of 1948 to instruments that recognize the rights of women, the rights of indigenous people, the rights of the disabled. So why we do have this expansion of human rights? Iprenta Baxi considers two epochs in the conceptualization of human rights: the modern epoch and contemporary epoch. Basically, the modern epoch of human rights is considered an era of exclusion. So it was the epoch of colonization as well. So certain type of human beings were entitled to human rights, other type of human beings, such as indigenous peoples, colonized people, did not have access to the rights. While the contemporary age of human rights began with the end of the Second World War and the emergence of the Universal Declaration of Human Rights, and it is based on an inclusion rather than an exclusion. So this is why we have been seeing this expansion of human rights law at the inclusion of the different manifestations of the human. But we need to ask ourselves how much of the modern epoch is still intrinsic in the contemporary human rights law system. Well, for Anne McGrath, the influence of the modern human rights paradigm still underpins contemporary human rights ideological structure. She tells us that this is very evident because corporations, and here I would like to link my presentation to what Professor Vestra said before. The thing is that corporations, they can defend themselves in court. They can use the language of human rights to defend themselves. The colonization of corporation in human rights law is very evident. The law in general is a rational paradigm. Okay, so it represents a legal disembodiment. The law, the human rights law, is not connected to the different manifestation of the human. It's an abstract concept. And I think that law needs to interrogate itself about what is law, where does law come from? And we could start by interrogating ourselves how non-Western indigenous tradition perceived the meaning of being human and how this perception of being human interrelates with the environment. The other issue that we need to consider is the anthropocentrism in law. Anthropocentrism, of course, led to the creation of law, to the creation of human rights, and to the creation of legal system that do only consider the human needs and the interests of humankind, and do not incorporate the limits that our human world has, and does not consider the needs of our planet Earth. Non-human living entities and non-living ones are treated as resources, and most often as resources that are unextinguishable. They never had to satisfy our needs. And this dualistic mind that we have seen before is inherent in all manifestation of Westernized law, the separation of human from nature. And of course, the right to a healthy environment is human-centered because considers the environment as functional to the needs of the human being. So I think that this is a very important step back that the law should take and interrogate itself, where it does come from, if it does include a planetary health, for instance. An alternative epistemical approach is represented by the right of ecological integrity. It's not the right to ecological integrity, because by using of, we wanted to communicate that this right is inherent to the ecological integrity. It's not something that we are giving to our planet. It's something that we are recognizing that already exists. So the right of the ecological integrity model considers as axiomatic that the biological integrity and functions of human beings are dependent on the integrity of the natural environment and on the integrity of our planet. Unfortunately, that we assume that thanks to technology and science and medicine, we will find a way to replace or reconstitute the damage that we have done to our planet. But this is just an illusion, because the reality is that we are dependent on our planet and not the other way around. Ecological integrity can be understood, can be conceptualized as a new standalone right that aims at repairing these disconnections, aims at repairing and reconstructing what we have done with breaking in this dual in this dual epistemological model, you know, the law and policy that derives. Okay, so and come to the conclusions. We have said that the right to healthy environment is a means through which it is possible to achieve ecological integrity somehow, but it is essentially an anthropocentric right. So we are in the same philosophical and legal model. Human rights present inherent flaws, and the very concept of Westernized law can be challenged. Alternative legal approaching are teaching us that our perspective is not the only perspective that exists. And the right of ecological integrity should be recognized as a standalone right. So this is all. Thank you for your attention, and we look forward to have some discussion or answer questions.
Thank you so much, Giada Emanuele. That was really thought-provoking, and I'm going to turn to Katie. I know she has a question. We have a time for a few questions. Thank you for keeping very much within time. So Katie, go ahead.
Sure, I have just two kind of short, direct questions, if I can sneak two questions in. First, you know, the right to a healthy environment focuses on individual rights. And I wonder if anything in Italy focuses on community rights, just, you know, in any broad spectrum in their law. And then my second question is most of environmental protection in Italy the landscape law? And or what other areas of the law do you find environmental protection? Because just with my limited understanding, I would think, you know, geographical indicators, food, culture could be very powerful allies. Thank you.
Thanks, Katie.
Thank you. Okay, I'll answer to the first question. Well, I can tell you that, as I said before, the right to a healthy environment is an individual right. The interest in protecting the environment. It is called in Italy, well, I think we can translate it as widespread interest, interesse diffuso.
Yeah, widespread interest.
Widespread interest, exactly. That is a widespread interest of a community of people, which can be exercised only by an exponential body. Can we say like that? An exponential body, which is the state, and in some occasions, bodies like associations.
Maybe.
Exactly.
Yeah.
So, as I said before, when I was distinguishing these two different interests, the individual one and the collective one, the Ministry of the Ecological Transition is so the state, is the only one entitled to ask to those responsible for environmental damage to compensate the damage. Okay, so not the single person, but only an exponential body that represents the community of people. Did I answer to your question?
Yeah, she asked also about the what are the other laws in Italy that protect the environment apart from the landscape thing of the Constitution?
Yes, there is an environmental code in Italy, which has been adopted in 2006. And in the first part of the code, there are many environmental principles, general principles about protecting the environment. So everything is inside that code in the first part of the code.
I wonder if I could jump in with it. Just a question about how the rights to an ecological integrity, how you see that relating to or resonating with the rights of nature movement that's emerging. Are they similar? Are they the same? Is one a subset of the other? Can they work together? Those kinds of things.
Thank you for your question. Indeed, in my research, I'm focusing a lot on the rights of nature and alternative epistemology. So I look a lot at how indigenous people consider the environment. And of course, I think that they are interrelated, because all my research is that we need to consider that our law, our model society, is not the only one existing. We do have other types of law, like indigenous customary law, to take into good consideration. So I think that they are strictly interrelated because they are part of an alternative epistemical approach to law and governance.
That's a long conversation, and I appreciate that answer. Maybe we can have that conversation later in the morning.
Yes, of course, I will love to. Thank you.
But it is now time to turn to our next presentation. So we'll turn things over to Ottavio Chirico, if I said that right. And Ottavio, the floor is yours. Are you going to be sharing your screen? Yes, you have. Okay, go ahead. And I will give you a 5-minute notice when your time is running short.
Okay, thank you. Can you hear me? Can you hear me?
And we can hear you, and we can see your presentation, although if you can get it into the slideshow mode, that would be best.
Into the slideshow mode, I will try. Okay.
That's the right place. Yeah. Maybe click twice.
I think it should be in the slideshow mode, isn't it?
Yeah, we're seeing 2 slides though. We're seeing your notes as well.
You're seeing my notes as well.
No. We're seeing 2 slides at a time. But you may be able to.
Okay, these I don't know why.
Why don't you just go ahead? We can see your slides, so it's fine.
Okay, I don't know why you're seeing 2 slides at a time. Maybe now you're seeing 4, probably. Is it okay?
Yes, now we see 2. but it's okay. Just go ahead, Ottavio. We can.
Okay, look, I don't know how to only show one, but all right, look, not to take too much time. Thank you all, first of all, for the opportunity of this presentation. Obviously, it is a pleasure to attend and present. Apologies for not attending many other sections, but I am based in Canberra and it is 9 a.m. Your time is 11 p.m. my time. The last time we met was in 2009. And I am now an associate professor of Australian universities based at the Australian National University in Canberra. And I am also a professor, qualified professor of Italian University and a member of the European University Institute in Florence. Actually, from October onwards, I will be based at the UI in Florence for at least 1 year. My area is fundamental international law, and I am going to focus on the question of the relationship between the right to a safe environment or environmental sustainability and the right to a sustainable climate, which is a question that, in my view, has not been given much attention in practice and in scholarly work. Now, the focus, it seems to me, has been and still is, in particular, from a human rights perspective, on the right to a healthy, safe, or sustainable environment. And specifically within the context of the question of the relationship between climate change and fundamental rights. That is, the discussion on climate change and fundamental rights started with the Inuit petition to the Inter-American Commission on Human Rights in 2005. The petition was simply rejected, and the answer why it was rejected is quite unclear to me. But fundamentally, the Inuit claimed in their petition that excessive carbon emissions in the US affect their fundamental rights because they have a negative impact on the Arctic, causing melting of the polar ice cap. And this would affect first and second generation human rights, such as the rights to food and culture, but also, and I quote, the right to a healthy environment, which according to the petition is a customary right under international law. Now, I don't think it is a customary right under international law, but this interpretation is based on the separate opinion of Judge Vera Mantri in the Gabčíkovo-Nagimaroš case, International Court of Justice, but this is a separate opinion. In any case, the focus is on first and second generation fundamental rights and the right to a healthy environment. The discussion has then continued at the UN Human Rights Council. And the first document is a document dating back to 2009. It is an analytical study on climate change and human rights. And again, the focus is on first and second generation human rights, so civil and political rights, economic, social, and cultural rights, and the right to a limited extent, also the right to a healthy environment, and the rights also of vulnerable groups. Vulnerable groups are particularly affected by climate change. And still today, the Human Rights Council focuses on the right to a healthy environment because there is a document of 2020, and the document is a document on the right to a healthy environment, which mentions the right to a healthy environment, which is fundamental. And there is today support for a universal recognition of the human right to a healthy environment which is widespread in civil society. And the document claims the global recognition of the human right to a healthy environment, which would advance efforts to protect both people and the planet. And the time for such recognition is now. So the focus is clearly the right to a sustainable environment. The former independent expert and special rapporteur to the Council on environment and human rights has taken the same approach, and in his last report, Professor Knox in 2018 claimed that the UN General Assembly should adopt a global instrument recognizing the human right to a healthy environment, which entails important and tangible benefits, as it provides a safety net to protect against gap in statutory law. And it also creates opportunities for better access to justice inter alia. The current special rapporteur, Professor Boyd, follows the same approach, and in a report of 2020, the rapporteur claims that there should be legal recognition of the right to a healthy environment at the global level. This approach follows soft law and hard law. Soft law, the first reference is the 1972 Stockholm Declaration, whereby Principle 1 recognizes a fundamental right to an environment of quality. And then we have the Brundtland Report and the Rio Declaration and the UNESCO Vizcaya Declaration. Among binding instruments, we have the African Charter on Human and People's Rights, Article 24. All people shall have the right to a general satisfactory environment favorable to their development. And also the San Salvador Protocol additional to the American Convention on Human Rights, Article 11, which is nonetheless not subject to adjudication. So the focus is the right to a sustainable environment in approaching climate change. Now, my view is that this approach creates some problems. And it would be better to focus on a right to a sustainable climate. Is there such an approach? Or is such an approach possible and viable? Well, let us say that the question has not been really considered much, at least from a human rights perspective. Now, the International Law Commission at the United Nations is studying the question of the protection of the atmosphere. There is a working group on this, and the focus is not on environment as such, but on the protection of the atmosphere. But still, the focus is not only climate, because the atmosphere, of course, includes, for instance, tropospheric long-range transboundary air pollution and ozone depletion, in addition to climate change. Guideline 3 of a draft prepared by the IRC on the protection of the atmosphere includes the obligation to protect the atmosphere, providing that states have the obligation to protect the atmosphere, exercising due diligence in taking appropriate measures to prevent, reduce, and/or control atmospheric pollution. Now, some states claim that this obligation is a universal obligation, erga omnes. Others, and notably China, claim that there is no explicit legal obligation placed on states to protect the atmosphere. such obligations have yet to materialize. So here, not only the approach is still quite broad, the atmosphere per se, but also there is discussion on the existence of obligations as concerns the operation of the atmosphere. Now, nonetheless, the reference here is, I think, the UNFCCC, the Framework Convention on Climate Change regime. So the convention and additional protocols. Here again, there is debate in the sense that does the convention and do related protocols create legally binding obligations, or do they rather create guidelines or principles? Now let us consider some provisions. Article 4 provides that states shall formulate and implement national and regional programs to mitigate climate change. This is considered shall an obligation, but soft in nature, as it does not set a precise standard of action. Article 2 establishes the objective of stabilizing greenhouse gas concentrations in the atmosphere at a level that would prevent dangerous anthropogenic interference with the climate system. Here it is considered by a majority of scholars that Article 2 creates a duty of prevention. And then we have the Paris Agreement. Article 2, in enhancing the implementation of the UNFCCC, states aim to strengthen the global response to the threat of climate change, including by holding the increase in global average temperature well below 2 degrees Celsius above pre-industrial levels and pursuing efforts to limit temperature increase to 1.5 degrees Celsius. Now, again, here there is discussion. The idea is that the Paris Agreement fundamentally establishes a substantive obligation, at least to make the effort to achieve the established objective. And again, there is the problem of the standard. Anyway, I think that although there is debate, it is undeniable that under the UNFCCC, there are at least some obligations of prevention. So we can speak of an obligation, duty, and right in light of the correlativeness, which I think is fundamental between rights and duties. Kelsen or Höfeld as well, we can speak of a right or rights probably to a sustainable climate. Now the problem is such a right, or possibly are such rights, but let us simplify, is such a right to a sustainable climate a fundamental one, or can we conceive of a fundamental right to a sustainable climate? Well, scholars have not considered the issue. In 2016, I published together with Professor Francioni a contribution in the volume edited by myself and a French colleague, Climate Change and Human Rights, a contribution on the issue. I think that this notion, to a certain extent, emerges in the case law, not always, but sometimes. That is, if we take the case of Urgenda, this approach does not emerge because the focus is, in particular, in the third and second instance, appeal and cassation, on the rights to life and private and family life, specifically under Articles 2 and 8 of the European Convention on Human Rights. But in the case of Juliana against the US, Now the case is still pending, although the question is problematic, but there was at least in a decision of 2006, a mention by the court for the District Court of Oregon of the fact that undoubtedly the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And in fact, a stable climate system is quite literally the foundation of society. And here I think it is quite isolated, but there is a mention of the right to a sustainable climate as a fundamental right, at least as a possibility. Okay, now to be brief and also to come to a conclusion, the point is to be a human right or to be conceived of as a human right, the right to a sustainable climate should be universal. And that's not the way in which it has been shaped and framed, because the right has been established under the UNFCCC as a relative right and duty, and mostly, if not exclusively, as an interstate right and duty. So is there any possibility of conceiving of such a right as a universal that is an erga omnes one, as a fundamental right? I think, but again, these are marginal considerations, so this is entirely new fundamentally. In certain activities carried out by Nicaragua in the border area, ICJ case, Judge A. Doc Dugard, but again in a dissenting opinion, mentioned the obligation not to engage in wrongful deforestation that results in the release of carbon into the atmosphere and the loss of gas sequestration services, certainly as an obligation erga omnes. So I found at least one piece of evidence that it would be possible to approach the right to a sustainable climate as a universal one. Now, of course, to conceive of it as a human right, this right should be individual-centered and not state-centered. So there should be a shift in focus. But here I think that some non-binding initiatives, and particularly the Oslo Principles on Climate Change, I think, and human rights, on climate change obligations, focuses on the responsibility of states as well as corporations vis-a-vis not only sovereign entities, but also non-sovereign entities and individuals. Of course, this is soft law. So again, it is not the predominant approach. Anyway, we have seen in the Shell case that a Dutch court has held a corporation responsible for breaching obligations related to climate sustainability, although not directly the right to a sustainable climate. So there is the possibility of a different approach, not state-centric, but individual, but an approach centered on the individual and fundamental rights and the fundamental right to a sustainable climate of the individual. Now, why would it be important to conclude really to approach the right to a safe climate, I would say to a sustainable climate, as a right and duty per se, rather than having a general right to environmental protection? I think that the right to a sustainable environment creates an intrinsic logical problem, I would say an antinomy, to mention Norberto Bobbio, who worked on antinomies in legal systems. That is, if it is an erga omnes obligation, and possibly a fundamental right, of course, there should be work should be done on the customary evolution. But at least there would be the possibility of thinking about such a right as a peremptory one as well. That is a non-derogable one, because it seems to me, and I have written an article published in the Fordham International Journal on the right to a sustainable climate as jus cogens, a right that is non-derogable. That is, we have to achieve the objective, because otherwise the consequences are catastrophic. And I think that there is support by civil society. There is this consciousness that has developed that the norm is peremptory. Also, there are 197 states parties to the UNFCCC and more than 190 that are parties to the Paris Agreement. So it is fundamentally universal and possibly peremptory, but this is a further step. Now, if we think of a right to a sustainable climate, we can think of it as a peremptory.
Ottavio has frozen for me. Has he frozen for others as well? Yes.
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 Checking if he's still signed on. Yeah.
His screen's still up.
Okay. Ottavio, are you with us still? Or did we lose you? Oh, well, that's too bad. If you had questions for Ottavio, why don't we go ahead with Anne's presentation, but save your questions. And then if Ottavio come back, hopefully we'll have a time if people want to respond in some way to what he presented. It certainly was a nice compliment to the first two sessions we've had on human rights. And now we'll hear from Anne. Anne, are you prepared to share your screen and so on?
I hope it works.
I see Ottavio.
Yeah, I'm back. I was disconnected for a moment. Apologies.
Oh, okay. So Anne, just hold off for a second.
Yes, I will.
Ottavio, are you were you wrapping up? I mean, we were.
Yeah.
Okay, so maybe why don't, if anyone, please raise your hand so I can call on you. I don't have anyone particularly to call on from the chats. If any, Don, go ahead.
There's lots of interesting questions. I don't want to raise them now, but put this in a future chat box of why nations aren't setting. Climate change violates the most basic human rights. So you don't have to go to the rights of nature, the right to life, right to health, and every ton makes it worse. Climate change is different than other environmental problems because all greenhouse gas emissions are raising the atmospheric concentration and making the harms worse. So if that's the case, why aren't people talking about when you set a greenhouse gas target, you should take that into account. And so there's all I'm saying is this is a bigger and important discussion. As we meet, there's a committee of people led by John Knox, which I sit in on, talking about this issue. How do we make human rights more effective? How do we publish? It's not only getting law, but getting citizens to understand, getting the press to understand that every ton makes the problem, creates more human rights violations all over the world. And the most basic, so it's an important topic. Thank you for presenting it, but it deserves its own conversation, I think.
Thank you, Donald. In fact, yes, indeed, that's my idea. It should be approached separately, and exactly then that's what I was concluding on, because if we think simply of a right to a sustainable environment as a human right, then it cannot be conceived of as peremptory. Otherwise, all the right to biodiversity, the right to protection against desertification, the right to protection of water courses, they all become binding. The approach is inflexible, so probably better to conceive of the right to a sustainable environment as a kaleidoscope or a compass of rights, or as a principle encompassing separate rights. Then we have a flexible vision, and then we can think that the right to a sustainable climate probably not only it is fundamental, but it is also peremptory. Then states and corporations have to achieve the objective because the objective is non-derogable. Then in that context, there is the problem of the obligation of contact or result. There's also the problem of 2 degrees versus 1.5, because 2 degrees, with 2 degrees, probably we can forget about the polar regions as we know them now. So this is a problem in the problem. But definitely, I'm in favor of a flexible approach, because otherwise, we have a logical problem, because we have no flexibility. That's the problem. It has not been studied as such per se. As you've seen, I've collected very little evidence.
I think if you haven't, the lawyers who haven't studied human rights law would find, when actually Laura's son asked me to teach in Japan for the first time, and I was amazed. I kept saying, "Oh my God, why didn't I know this?" Okay, I did. It solves not only it solves other problems, it solves standing problems. Human rights courts are all over the world, and they're agreeing on a lot the implications of human rights, because so there's a lot to talk about that I didn't know as an American lawyer, and I'm still amazed that the advocates don't take better advantage of it. And I think it's our job to help them see, and the press see, how hypocritical the fossil fuel industry is. So that's another. So I'll stop, but I want to park it for a future conversation.
Look, it is rich indeed, and also it is a new, really, it is a new way to approach the problem. And I think that if it was to be declared as a peremptory norma, it would be the solution, legal solution of the problem, because it becomes non-derogable, and the states have to abide by the obligation and achieve the objective, at least if it is conceived of, then that would take 20 more minutes, as a goal-oriented obligation of result. Because if it's just an obligation of conduct, yeah. But that's
Just follow him, his instructions. I will.
Okay, look, I think we are pretty much out of ready to shift. I don't see any other questions coming forward. But again, thank you very much for Ottavio and for Don for that question. And Anne, if you're ready now, we will turn to you, so you can go ahead and share your screen and take it away. We're not hearing you. If you'd like to unmute, we can try to help. We're not hearing you, Anne. You're muted.
I had to go back a screen, so I'm now going to have to find my PowerPoint again. I'm sorry.
You can go back once you've shared your screen too.
Just 1 second.
Okay.
It was okay. Now, is that screen share up there now?
No, you need to hit share screen, then select
okay
PowerPoint, and then hit share.
Oh, okay.
I also have your presentation. Oh, you did it. Yay. Okay.
Well, it's not up there yet. Ah, there it is.
So now the last thing is just to try and get it into presentation mode if you can. At the very bottom where it says notes, you can hit the fourth icon over where it looks like a little screen.
Now I do not, oh, annotate, remote control.
Notes in the white part.
I don't see a white part.
Right next to your cursor right now, right above where it says sunny.
Oh, here.
Notes. Go straight up.
I'm on more.
Your cursor right now is just below where you need to be. Go down to the little thing that looks like a screen. Do you see the word notes right under your cursor right now? There, click
Oh.
that. There you go.
Okay, but I've lost my ability to move my slides. I think.
You can use it. You can your arrows will still work.
No, they're not. Okay. There we go.
Okay, take it away, Ann.
Okay, thank you very much. I'm Ann Benton. I'm here in Toronto. I've come to a number of these conferences over the years. Most recently, I was a member of the Immigration Refugee Board here in Toronto at Immigration Canada. And I have had interest in ethical issues for a period of time. But today I'm going to talk about social media and the internet and regulating them to reclaim democracy. Now, the regulation of social media and the internet is necessary to reclaim democracy. Social media platforms have attracted a lot of media attention since Donald Trump became president of the United States in 2016. This interest in social media and the realization that government and corporate governance is needed to control the excesses and illegal activities of these platforms has created a dialogue in the editorial pages of major North American newspapers, in the world of academia, and North American around the world. I propose to show how understanding the underlying business model of social media is key to understanding the social pathologies that stem from it. This business model is discussed in Surveillance Capitalism, a book published in 2019 by Shoshana Zuboff. Further, I will refer to Ron Diebert's 2020 book, Reset, Reclaiming the Internet for Civil Society. It exposes the disturbing influence and impact of the internet and social media on politics, the economy, environment, and humanity. Ebert says that we need to educate people in the importance of tolerance, difference, and civic virtue. We cannot just blame others. We must look at ourselves and the priorities that we have put forward as societies in terms of educating people. However, rather than abandoning the internet, Ebert says we must think about bringing better governance around this ecosystem. We must design it to bring out the best in technology and help us to improve ourselves collectively. Now, Ron Diebert, Citizen Lab founder and director, he was selected to deliver the 2020 Massey Lectures here in Canada. And they were published in book form, Reset, Reclaiming the Internet for Civil Society. They were 5 lectures delivered online, streamed on the CBC, the Canadian Broadcasting Corporation Radio's Ideas, and published, as I mentioned, in a book, September 2020. To tell you a bit about the Massey Lectures, to give some context, since 1961, CBC Radio has been broadcasting the Massey Lectures, bringing Canadians some of the greatest minds of our time, exploring ideas that make us who we are, and asking the questions that make us better human beings. CBC's partners in the Massey Lecture series are Massey College in the University of Toronto and Anansi Press, publishers of the book Lectures. And some of the lecturers since 1961, just a couple to show you the breadth and the importance of the ideas. John Kenneth Galbraith, 1965, Martin Luther King Jr., 1967, Jane Jacobs, 1979, Willy Brandt, 1981, Noam Chomsky, 1988, Margaret Atwood, 2008, Margaret Macmillan, 2015. Now, in his book, Reset, Diebert exposes the disturbing influence and impact of the internet and social media on politics, the economy, the environment, and humanity. In an interview on TV Ontario's Agenda, Diebert says that something has gone terribly wrong with the great democratizing promise of the internet. He asks what can be done and where to start. And he goes on to discuss how fixing social media can help repair civil society and democracy. Surveillance capitalism is the underlying business model of social media and is key to unlocking the social pathologies that stem from it. This business model is an economic system centered around the commodification of personal data with the core purpose of profit making. The concept arose as advertising companies, led by Google's AdWords, saw the possibility of using personal data to target consumers more precisely. Basically, social media want to gather as much information as they can from us, their users, in exchange for the use of their products and services in order to monetize the data and sell it to advertisers, other business clients, and increasingly to governments. This underlying business model leads to secondary consequences and effects that explain a lot of the problems around social media. The imperative here for social media is to capture and retain users' interests. To do this, platforms invest a lot in understanding human emotions and the types of content that capture and retain our interests. Unfortunately, human nature is attracted to content that is extreme, sensational, emotional, conspiratorial. And so the platform's algorithms select out that kind of content and prioritize it, resulting in a toxic environment. In this way, social media and the entire communications ecosystem help propel forward authoritarianism and those who want to create chaos, division, and undermine society, including disinformation campaigns. However, Diebert notes that we live in a small and increasingly shrinking global public sphere. We have a shared habitat with real existential problems that we face collectively. And to solve them, we need the internet to exchange information, to monitor ourselves and the planet. The problem is that presently, the internet and social media revolve around surveillance capitalism. Rather, we need to think about bringing better governance around this ecosystem. Design it to bring out the best in technology and to help us to improve ourselves collectively. Restraint is needed to prevent concentration and abuse of power. Diebert sees hope in the restraint mechanism that has been the philosophy and focus of political theory since ancient Greece. He states that civic virtue is key to this restraint mechanism. At the end of his book, Reset, Diebert puts forward a tradition of thinking about security and liberty that people have drawn from over millennia, to think about the problems around the organization of our political life. The key idea is the concept of restraint, which is applied not just to governments, but to the private sector, civil society, and to ourselves. At the center of this notion of restraint is the idea that humans are subject to faults, including greed, abuse of power, and corruption. Therefore, liberal Republican thinkers have the idea that restraint mechanisms need to be designed into our society to prevent the concentration and abuse of power. Civic virtue is an important restraint mechanism. Today, Western civilization has lost sight collectively of what it means to be a citizen, what it means to be part of a larger collective. It is not just what rights we have, but responsibilities that we have to the larger social order. How do we get out of these echo chambers to hear each other out and practice that restraint which is necessary? How do we cultivate the ability to listen as citizens, as human beings? Diebert says that public education is important to achieve this goal. We need to educate people in the importance of tolerance, difference, and civic virtue. We cannot just blame others. We must look at ourselves and the priorities that we have put forward as societies in terms of educating people. However, he is optimistic about the future and gives examples to show that steps have been taken in the past year to listen to the points of view of others. There have been hearings in the US Congress regarding antitrust, which is a restraint mechanism on companies. Another hopeful sign referenced by Ebert is acting locally. For example, recently in Toronto, Alphabet, the parent company of Google, was proposing to make Toronto waterfront a smart city. The project, named Sidewalk Lab, had aimed to transform Toronto's waterfront area into a smart city providing autonomous cars, robotic rubbish collection, smart air quality measurement, and heated streets. The project was to be built from the internet up in a fully wired system that would collect vast amounts of data on residents, including purchases and virtually everything they did daily. The project ended in May 2020 after several delays and strong criticism from citizen campaigners who expressed privacy concerns. The Sidewalk project was labeled Surveillance City. Reservations were also expressed by Sidewalk Lab's own advisors. What was encouraging here, according to Ebert, was the fact that civil society in Toronto concertedly asked for greater civic accountability, pressing the company, pressing the authorities. Therefore, if we all start to act locally, we can bring about some of the restraint mechanisms described in Reset. Is regulation possible? Can society rely on social media to self-regulate in the future? If not, government regulation as well as corporate regulation is needed. A recent opinion piece in the Globe and Mail, a major newspaper in Canada, asked the question, should governments work with Facebook rather than attack it? The author argues that big tech firms should not be crushed by regulators like the US Federal Trade Commission, but be seen as allies to be worked with, leveraging the public goods they create for everyone's benefit. He continues, mandates by state bodies while respecting private enterprise ensure firms deliver long-term value to society, not just short-term profits to shareholders. He adds that the breakup of big tech would deprive governments and people with access to the world's biggest digital infrastructure, rather than treating it as a public good, which, for example, could be used to deliver government services. The other side of this argument states that the role of government should be to manage private companies and markets for the public good, but not necessarily create a friendly environment for them. Rather, the US Federal Trade Commission should break up big tech companies, which generate excessive profits resulting in wealth inequality, which is an undemocratic outcome. However, the suggestion that businesses should be responsible for corporate citizens, while laudable, seems to ignore the myth of corporate responsibility for anything other than shareholder profit and customer benefits. Social media has taken some steps to regulate content, but this has triggered opposition by those who say these limitations are an infringement on free speech. It does not seem as if there will be any quick answer. History of media regulation. In the 1960s, the University of Toronto professor Marshall McLuhan warned that the electronic global village would lead to tribalism. A current public opinion piece in the Globe and Mail reminds us how much has changed in 2 decades in the media ecosystem. It states, post-1990 advocacy journalism began its takeover. Under President Ronald Reagan, the Fairness Doctrine, which required broadcasters to have balanced coverage, was eliminated. Then came Fox News and the internet and social media and Twitter. Suddenly, everybody had a soapbox, free license to debase the public discourse with their biases, insults, and ideology. Cyber law in Canada. One problem is that in cyberspace, the normal rule of law, such as traditional policing systems, property law, courts, and sanctions, are difficult to apply. Several commentators, including Ron Deber, suggest that we must engage with platforms and move forward. In early 2021, there have been several incidents where governments clashed with social media platforms regarding regulation. One example occurred in Australia when the Australian government pressed Facebook to share media revenues with media companies. The Canadian Prime Minister, Justin Trudeau, outlined his plans to regulate social media in January 2021 mandate letter to Public Safety Minister Bill Blair. The Trudeau government states that it has made plans that include combating online hate speech and harassment, ideologically motivated violent extremism, and terrorist organizations. It suggests that the RCMP and CSIS will be equipped to deal with this growing threat. The Heritage Minister and Justice Minister are also referenced. And it was noted today, again in the Globe and Mail, that Bill C-10, which is I'm talking about here, that the Trudeau government has put forward, may die on the order paper because the Senate will not pass the law in a timely fashion, and an election may happen the end of the summer or in the fall. So you can see that these things are very difficult to move forward with. News sources say that the legislation of the current government in Canada will likely involve. However, questions arise regarding how such legislation will square with the Canadian Charter of Rights and Freedoms. The jury is still out regarding the Trudeau government's plan to regulate media in Canada. In conclusion, I'm going to mention some thoughts of Pope Francis and John Ralston Saul. Pope Francis states, when media and the digital world become omnipresent, their influence can stop people from learning how to live wisely, to think deeply, and to love generously. This phenomenon has arisen because a large segment of our modern society is characterized by what John Ralston Saul calls the unconscious civilization. Citizens are unaware of or indifferent to the common good and have little knowledge of environmental, political, and economic systems and how their lives and those of their fellow citizens are negatively affected. Citizens do not exercise their right and responsibility to participate in public debate, to talk about public issues, and to participate in assemblies to define the common good. As a consequence, democracy has been eroded by corporatism, with the result that the nominally democratic regime is in fact an oligarchy in which the economic system dominates. The collateral damage to the common good is degradation of the environment, a loss of ecological integrity, excessive economic inequality, and a dysfunctional internet system. As a community of concerned citizens, we demand a stop to the unregulated proliferation of social media and internet platforms that are impacting society today. Rather, we must raise the awareness of citizens regarding these dangers through public education and lobby our political representatives for appropriate legislation to regulate them. Thank you very much.
Thank you, Anne, for that presentation, for being very succinct in your time. That leaves us a fair bit of time now for some questions and discussion. So I'll open the floor. If you'd like to speak, just raise your hand. Either I can see you once the screen share stops, or you can use the raise the hand function. There we go.
Maybe I can just elaborate on what Anne was saying about emerging Canadian legislation on governing the internet or the lack thereof. This Bill C-10 was basically still sort of focused on economic considerations like taxing Netflix to support Canadian content and movie and television production and so on. But it really ran into snags in both the House and the Senate, which is left it tabled because there's a lot of objection to the fact that maybe not only corporate platforms would be governed, but individual citizens' postings of one kind or another. And that strikes me as such an oxymoron, because there's an awful lot of hate speech and things like that individuals are posting, and I think that's really what the government tried to if you will, sneak into this legislation that didn't work. They're also promising, if they stay in power, and because they've already introduced a bill that would more directly address things like hate speech, anti-Semitism, misogyny, and discrimination of one kind or another. And it remains to be seen where that's going to go.
Thanks, Rose. Does anyone else want to jump in? Go ahead, Don. You're muted, Don. You're still muted, Don. I can try to unmute you. You should be. Yeah, for some reason you're still muted, Don. This is set to allow everybody to mute and unmute themselves.
I think again,
there you go.
Just what an important topic. Okay, and what we do about it, it's so important. It's so destructive, but it deserves. What the hell do we do?
Can you speak up, Don?
Okay, several countries approached the EU several years ago to see if the EU would be interested in regulating, and the corporate hatred of the EU, I think, was responsible for everyone attacking the EU at that time. So you can expect, if anyone tries to regulate this, unlimited corporate disinformation. So to be continued. It's an important topic. What do we do about this? I think everyone agrees with your premise, and I thank you, because you gave me some angles that I didn't see. So I thank you.
I guess one thing I'm wondering about here is you have places like China, and we hear of other regimes that just they can shut down. They have such fine controls over various information platforms, including social media. And in the U.S. in this part of the world, there seems to be reliance on Twitter kicking Trump and other people off, or other organizations, or Facebook kind of tiptoeing and mealy-mouthing its way to an approach to Trump in the long term. Where's the happy middle here?
Go ahead, Ann.
No, Rose.
Yeah, well, I just wonder how many of you have seen or heard of the documentary, The Social Dilemma, that really illustrates the extent to which algorithms are now controlling what's happening on the internet, and encouraging silos, and all the things that Anne was talking about and others have alluded to as well. And a number of people in that particular film are from Silicon Valley. I mean, people with a good deal of knowledge on how this all works, especially in the aftermath of the political interference for the 2016 election and others, that we need some kind of rules of the road, or the cybersecurity. So it seems to me that there's a growing consensus within the tech industries themselves that we need some kind of regulation.
Mm-hmm.
And a lot of people are watching what emerged from Australia. Certainly in Canada, there's a lot of attention being paid to the legislation that, the controversy that erupted.
Facebook,
yeah, it was Facebook, and I think Google to some extent as well.
Yeah.
Google settled with the Australian government.
I don't think Facebook did. But the major issue, the government was trying to get Facebook to share some of their profits.
Yeah. Social Dilemma is still on Netflix for anyone that's interested.
Okay, well, thank you, Rose and Ann. Ann, I'll give you sort of one more chance to wrap things up here before we break?
Well, I think this is obviously a very important issue, and so many different levels of government are involved, and business, civil society, all trying to work together, more or less, to come up with a consensus and a way to move forward, because the internet is basically such an important tool, as Diepert says. It provides an infrastructure for communicating around the world. We mustn't write it off. We mustn't, as they say, throw out the baby with the bathwater.
Okay. Well, thanks, Ann, and we'll hear a few more presentations this afternoon on these issues, on digital technologies and other kinds of technologies and their impacts on society and their resonance with some of the other issues we're talking about. I put in the chat that I have posted the YouTube recordings for the first 2 days I'm working on yesterday, and at the when we're all finished, we'll have a full set of recordings. We missed a little bit of yesterday morning. We just did not have the recording on, but most of the sessions are recorded, and feel free to look those over and share them and so forth. They're all, the links are also in the community board bulletin. So we will have our last session this afternoon. Giada will guide us through that. We have some terrific presentations on again, these digital and technological issues, and also on indigenous rights issues and indigenous issues. So I think we're all really looking forward to that. And at the very end, Laura and Virginia will be sort of closing things down and starting the transition to next year together in Salerno. So let's take a break. The Zoom will be opened if people want to hang out, but we will stop the recording for the break and restart that at 2, and we'll see you then. Please do try to get here to start right on time at 2, so that we can wrap up pretty much at 4 o'clock, when Laura's going to have to leave.
Okay, Jeff, and Katie has asked me to be sure to log on at least 15 minutes before 2, so that you and I can do a little test with my slide presentation. Okay?
I'll be on it then at 1:45, no later than that.
Okay, 1:45. Thanks.
We better start that now than forget about it like I did in one session. So I can trim off.
2 o'clock. Let's get going.
It's not quite 2 o'clock yet, Laura. We'll start right at 2. So we're almost at 2 o'clock. If everybody who's not presenting could mute themselves, and then Giada, when you're ready, I think when it hits 2, you can just start the panel.
Yeah, sure. Welcome to this section of the Global Ecological Integrity Group Conference. This panel is entitled Ecological Integrity and Human Rights, and is the second today about this subject. So we're going to have our first presentation for this panel, which is Empowering Mother Earth to Assert Indigenous Rights by Bradford Morse. Therefore, you're going to have 30 minutes, and I will tell you when you're about 25. You're gone 25 minutes. So and then you can leave the last minutes for questions. So the floor is yours. If you can introduce yourself, thanks a lot.
Tēnā koutou, tēnā koutou, tēnā koutou katoa, ko Brad Morse tōku ingoa, Waita Waitkup, Brad Morse and Quest. I'm acknowledge that I'm speaking to you from the traditional lands of Tk'emlúps te Secwépemc, which is unceded traditional territory of theirs, but as part of the Secwépemc Nation, their territory called Secwépemc Ulu. Today, as was mentioned this morning, is Canada Day. It is the national holidays that is intended to celebrate the birth of Canada, that officially came into existence on July 1st in 1867. But today in particular, many of the Canadian flags are flying at half-mast. A number of communities across the country have canceled their Canada Day celebrations, including the city of Victoria, which is capital of the province of British Columbia. I live in the city of Kamloops and can see Tk'emlúps te Secwépemc First Nation across the river for me. The reason why today in particular is a sad day, it's often a sad day for many Indigenous peoples because they see the creation of Canada as only confirming the colonization that occurred on their traditional territories across these lands, and in which of course they were not involved in any way. The original leaders of 6 colonies engaged in negotiations about what the terms of this founding constitution would be. British Columbia and Prince Edward Island ultimately dropped out of that, leaving New Brunswick and Nova Scotia in Eastern Canada, a much smaller province of Quebec, formerly Nouvelle-France, and a much smaller province of Ontario as the founders of the country. Indigenous peoples were not involved, they were not present in the negotiations, they were not consulted in any way. And in fact, that constitution, the British North America Act, which was passed by the Parliament, House of Commons and House of Lords of the United Kingdom Parliament, to give force to the creation of this country. The only reference in that founding document is in section 91, subsection 24. There's really an afterthought. Indigenous peoples were not part of any of the records of discussion to speak of within those negotiations, and it simply empowered the newly created federal government through the Parliament of Canada to be able to pass laws for what is stated to be Indians and lands reserved for Indians. And so that's the backdrop of today's celebration. As many of you have already heard, of course, today is an added sad day because all Canadians have been reminded of the horrendous abuses, mistreatment, and efforts to assimilate Indigenous peoples through what are generally called Indian residential schools, although there were residential schools that also involved the Inuit in Northern Canada that came into being much, much later. And there are also Métis peoples that were present in a number of the schools. This community I mentioned previously, Tk'emlúps te Secwépemc, is the first community that came forward with a report of 215 Indigenous children whose human remains have been identified through ground penetrating radar as being in unmarked graves. We subsequently have had 751 children identified at the Cowessess First Nation in Saskatchewan. And earlier this week, we've had, I guess 2 days ago now, had more children identified at the Lower Kootenay First Nation in Eastern British Columbia. So we've now had already 1,148 Indigenous children so far identified as their human remains are in unmarked graves. We'll see this unfold at residential schools all across the country further such studies are already underway and many more will follow. So for many communities, indigenous and non-indigenous, today is on the one hand, we're acknowledging the existence of Canada and it is a wonderful country, but it has a horrendous past that is still not fully come to grips with, although that's become much more apparent today. Let me move on to the purpose of this presentation is to demonstrate how where Indigenous peoples are vigorously asserting their rights and are acquiring state recognitions of those rights, that can have not only an extremely beneficial impact for them and their communities, but also on the non-Indigenous peoples within their countries, and as well as helping to save critical spaces on our planet. And so I'm just going to discuss a few of those. Klaus Bosselman mentioned the situation of two of the treaty settlements in Aotearoa, New Zealand yesterday in terms of Te Rewera as a former national park, now effectively controlled by the Tūhoe iwi or Tūhoe tribe, and also then Te Awa Tupua Whanganui River Claim Settlement from 2017. And that's where we see rivers gain legal personality status. Te Rewera gives that legal status to that territory that is now managed predominantly by the Tūhoe, but with the Department of Conservation for the New Zealand government as well, that obtained legal personhood also. So in Uluru and kind of Judah National Park in Uluru in particular, formerly called Ayers Rock, has been an iconic symbol of Australia. You see it on lots of calendars, on all the Tourism Australia materials, etc. Kata Judah or the Olgas, Mount Olgas, are also distinctive because they seem to just kind of erupt out of the semi-desert landscape. This is the territory of the Arnunga people who believe they're the direct descendants of pre-human ancestral beings who've created this general territory. Their evidence indicates that they and their ancestors have been there for about 30,000 years, whereas the first Europeans arrived there only 149 years ago. This land generally was recognized by the Arnunga people under the Aboriginal Land Rights Northern Territory Act of 1976. They formally acquired a native title to a large block of their land, but not the park because it was already considered occupied by the Commonwealth government. But that was transferred as well in 1989 with the 99-year lease back. And this is one of the earliest examples of Indigenous peoples getting territory that has had an effect on a park and has led to Indigenous co-management of that park with Parks Australia. It's a double World Heritage Site. It's got a co-management plan now in place in which the Arnunga are very actively involved, has emphasized protecting their cultural heritage, preserving biodiversity, restoring ecosystems, controlling tourist numbers, removing the tourist facilities from the site, ensuring that sacred sites are closed off, educating the public about their culture and traditional knowledge, and managing it both through the use of Indigenous traditional knowledge as well as through modern science. And a demonstration of how this has worked so well is that the Arnunga have declared 50,000 square kilometers or larger than the country of Switzerland of its recognized native title lands that surround the park now as an Indigenous protected area. Another national park that's come about affected by national rights is Kakadu National Park. It's the largest terrestrial park in Australia, just under 20,000 square kilometers, or half the size of Switzerland, created over a number of years, in part because there was a uranium mine already effectively operating in the area, and there were several other sites identified as being uranium rich. And so there were chunks of land that were kind of excluded, that original mine site, and those two other potential mine sites were also pulled out of it. And so the park and the Indigenous interest in that lands was kind of surrounding this Ranger uranium mine, which only shut down earlier this year in terms of the last of the ore being processed, although the open pit mining itself stopped about 8 years ago or so. So again, this is a UNESCO World Heritage Site. In 1987 for its universal natural values, in 1994 for its universal cultural values, especially due to the sacred sites within it. Kakadu also is under co-management, a somewhat similar structure to the one at Uluru. The majority of the board here again are Aboriginal appointees, one of whom is selected by the board as a whole, but one of the Aboriginal appointees is to be the chair. The director of parks for the Kakadu National Park has to consult regularly with the National Land Council, which is a larger body that helps represent traditional owners in kind of the northern half of the Northern Territory. But even for the lands that are not formally Mungay peoples, they are still treated as if they were Aboriginal owned land. So the Parks Australia has really kind of come around in many ways to seeing the value of treating land as Aboriginal lands and having those kind of positive relationships. Buderi National Park and Botanic Gardens, just a little small one. It's in the Commonwealth Territory, so this is directly part of the national government in a sense. Created in 1915 because it's the nearest port. Canberra, the capital of the Australian capital of Australia, and in Australian Capital Territories inland. So this land was created as a park, somewhat like Kakadu and Uluru, that then later gets converted by the land being transferred, in this case to the Wreck Bay Aboriginal community, and then they've leased it back to Parks Australia and co-managing it. The other big important development is Indigenous protected areas, and launched in 1997 to encourage Indigenous communities to dedicate some of their land or sea country, particularly lands that have been recognized under the Native Title Act of 1992, that is an outgrowth of the Mabo decision of the Australian High Court to recognize that Australia is not terra nullius or vacant land when the British arrived, but in fact has been occupied by Indigenous peoples of various generations. Now it looks to be parts of it have been occupied by Aboriginal people for 65,000 years. And so as a result of the Native Title Act, lots of Crown land has been claimed, and there's many of which have been successful. And what this IPA's scheme is to try and encourage Aboriginal peoples and Torres Strait Islanders to set aside some of those lands to be Indigenous protected areas. So as of last year, there were 78 dedicated IPAs, that total 740,000 square kilometers. That is just under 50% of the National Reserve System. There are 800 Indigenous employees, and what that speaks to, while they're predominantly Indigenous employees, that these are lands that are really being caretaken, but in a very, very, if you will, gentle basis. They're not being lands that are being exploited in any kind of significant way. The Commonwealth government just announced, I guess now it's 2 months ago, $100 million to protect ocean habitats in coastal areas, and 11 million of that is to fund expanding these IPAs to include more sea country. Because again, under the Native Title Act and the Aboriginal Land Rights Northern Territory Act, as well as some state native title statutes, there includes some offshore lands as being part of their territory. So all told, that creates an extraordinary amount of land. And my rough estimate of this is that in fact it is larger than, significantly larger than France and Italy combined, to give you a sense of how much land we're talking about. Let me switch quickly to Canada. And again, here the big change has been the assertion of Aboriginal title rights, following particularly on the Supreme Court of Canada decision in Calder versus the Attorney General of British Columbia in 1972. Interestingly, that decision became a major foundation of the Australian High Court's decision in Mabo coming along 20 years later. While the Niska Nation did not officially win the Calder case, the 6 of the 7 judges recognized that Aboriginal title was part of the Canadian common law, and that was sufficient to persuade the federal government to change its position, and particularly Prime Minister Trudeau's position that there could no longer be any treaties internally within Canada. Treaties were only with foreign nations. He backtracked on that relatively quickly after this decision. By August of 1973, so about 9 months after the Calder decision, and the federal government accepted that they would engage in comprehensive land claims negotiations with Indigenous peoples in Canada, where they could assert that they were the descendants of the people who occupied that territory when the Crown kind of came along and tried to assert its sovereignty. This has effectively been seen as a win-win when it comes to the environment, in the sense because many Indigenous peoples want to ensure permanent protection of sacred spaces and territory that's important for their continued survival, both in traditional economic terms, but also in spiritual terms. And by negotiating with Parks Canada, they get the access to federal money in particular, as well as some modern scientific expertise to match with their Indigenous traditional knowledge, and have an opportunity to engage in some co-management. From the Canadian government standpoint, it's seen the creating of parks and wildlife preserves as politically popular. It speaks to a Canadian desire to have more of our fantastically beautiful country protected for future generations. It meets international pressure for greater presence of sea territories and land territories being set aside and protected. It also promotes tourism, which is a significant benefit to the economy, and it fulfills the Canadian government's own goals for the protection of the environment. And so let me just quickly flash through here, pointing to just some of the beautiful places. Nahanni National Park is one where that Prime Minister Pierre Elliott Trudeau, not his son Justin Trudeau, our current Prime Minister, set aside land in 1972 prior to the Calder decision to become a national park, but it was put in reserve because there was a thought that there might be land claims there in the Northwest Territories. Those claims went on for decades. Ultimately, an agreement on temporary protection of it and extending that to 23,000 square kilometers with approval of the Decho Nation, then Canada adding 5,400 more square kilometers. In 2009, announced legislation to increase it to 30,000 square kilometers. It's been one of 4 of the very first World Heritage Sites identified by UNESCO in 1978. It's still, in fact, not yet a national park, but it's in the process of formally being confirmed, but it is being treated effectively by Decho and with some Métis involvement, and Parks Canada as a park. So it's in the process. And given, despite the size of this, we're talking 30,000 square kilometers. It's getting under 1,000 visitors a year. Herschel Island is the first one officially to come under a land claim settlement, in this case with the Inuvialuit, who are Inuit peoples in the Western Arctic in 1984. Their Inuvialuit final agreement included provisions to create a park. This is formally in the Yukon Territory, where no Inuvialuit people live, although their descendants did, and it's now a co-managed park by the government of Yukon and the Inuvialuit. Olavik National Park is another one created under that agreement, 12,200 square kilometers. It is jointly managed by Parks Canada, well, 4 representatives and 4 representatives from Saxe Harbor, Nunavut. Again, a spectacular territory, hardly any tourists. It's preserved as is, significantly important, particularly for survival of adult muskoxen. Vuntut National Park is another one in northern Yukon. Vuttun Gwich'in First Nation created this in part under their land claim settlement, and they've subsequently expanded that. They have a block of land inside this park, along with there being a wildlife preserve. It abuts the Arctic National Wildlife Refuge in the United States that Donald Trump wanted to open up for drilling, and the Avavik National Park to their east. So it's a huge area. It's also vital to the survival of a particular caribou herd. Tuktuk Nugget National Park, another one, another large one, 18,000 Inuit pushing to protect the blue nose herd of caribou. It's since, that herd is revived quite significantly. Another co-management board. Ninli Nijik Fishing Branch is a territorial park, so created again out of Vuntut Gwich'in settlement lands with some Yukon territorial lands and a wildlife preserve around it. Again, another significant site. Niska Nation that started the Calder case, they finally reached a treaty in 2000. They are co-managing 3 protected areas within their traditional territory. They're specifically defined by that treaty. Two of those were existing as provincial parks beforehand, but they're further defined, and now the third one is a new one. They're all co-managed with the provincial government due to the treaty. Torngat Mountains takes us all the way to the eastern coast in northern Labrador, the Labrador Inuit land claim settlement. This agreement settlement was done in 2005. The park itself was postponed a little bit while their Inuit neighbors in northern Quebec finished another land claim agreement, and so it's now the largest national park in Canada. Nahanni National Park takes us back up to the north. And this is another one now in kind of central Northwest Territories. So here's another one that is on the west coast of Vancouver Island. So all of these are ones that have come about really through land claim settlements. Great Bear Rainforest is also one that's gotten particularly a lot of national attention because it is one of the last of the large tracts of unspoiled rainforest in the world. Has 1,000-year-old western red cedar, 90-meter high Sitka spruce. It's a coalition of environmental NGOs and First Nations lobbied for years with the provincial government to stop logging in the area. Ultimately, an agreement was struck recognizing Aboriginal rights to shared decision-making, a greater share of timber, and $15 million to the First Nations in the area for economic development. 85% of it is permanently protected within this rainforest. Does, however, still mean 15% is available for logging. So there is still lobbying going on to stop that. In fact, stop all old growth logging in all of British Columbia. This is another protected and conserved area in the Northwest Territories in the Dehcho region that's come along now even later, just 3 years ago. Again, vital for some of the wildlife, particularly lesser snow geese and tundra swan. Taidin Nene National Park was just created 2 years ago after 49 years of effort to bring about, and it's already been expanded in size. Again, it's a co-management. In this case, we have the feds, government of the Northwest Territories, and 3 First Nations all involved in the management of this park. So what this is showing really in sum is that many parks and protected areas in Canada while many are unconnected to Indigenous rights, the largest in Canada being Thélan Wildlife Sanctuary that is twice the size of Belgium, created in 1927, but it's and expanded over time. So they're not all involved, created through land rights, although Aboriginal and treaty rights and the constitutional protection of those rights impacts on them. And another one, Wood Buffalo National Park, which is the largest one in Canada at almost 45,000 square kilometers, over 17,000 square miles, created in 1922 and a World Heritage Site. Nevertheless, it's created out of territory that was set aside under Treaty 8, and those Treaty First Nations have treaty rights in relation to that parkland, which means that they have the rights to hunt and fish and trap in that land. It also means now under Canadian case law, the government of Canada must consult them whenever they're thinking of making any proposed changes to that. And they were slapped down by the Supreme Court of Canada for failing to do that, as they proposed to put a road through part of that parkland that would have destroyed some trap lines. So this Indigenous rights dynamic and the environmentally driven protection of territories within Canada and Australia both have had a happy marriage in many circumstances. However, there are many other places where these struggles are still continuing, and where Indigenous peoples in particular are still struggling to have their rights in relation to their traditional territory recognized. And let me stop there.
Thank you, Brad, for this presentation. It was really great. Myself, this is exactly my area of research, so I have like 1,000 questions, and I would love to connect with you beside this conference to have a chat about Indigenous conservation areas.
Sure, well, let's do a Zoom session.
Sure. We do have a question. I mean, there was a huge debate in the chat about colonialism and cultural genocide. And we have a question from Jeff. He's asking about the Trudeau's government's new legislation on implementation of the UNDRIP in Canada, and if it goes far enough to expand examples of Indigenous empowerment over certain lands, also in the rest of Canada.
Okay, let me try and very quickly deal with both of those. The first legislation in Canada was passed by the British Columbia government late in 2019. We're now, I guess, November 2019. So, we're about 17, 18 months, I guess, into this. That legislation is already in force, imposes obligations on the government of British Columbia to bring British Columbia laws into compliance with UNDRIP, file annual reports, create a national action, action plan in partnership with Indigenous peoples in the province. They filed their first report last year after only about 4 months or so of the act being enforced. We're expecting another report kind of any day now for the last fiscal year. The federal government has just passed, or I should say Parliament of Canada has just passed a bill C-15 that made it through both the House of Commons and Parliament and Senate. Received royal assent a week ago Monday on National Indigenous Peoples Day, which was a particularly appropriate day on which to announce it. It's also drafted jointly between Indigenous leaders and their legal teams, some of whom were involved in the BC legislation that have kind of brought that experience with them into those negotiations. Again, like in BC, these negotiations were very closely connected to the ministers responsible. In the federal one, it was the Attorney General and Minister of Justice of Canada, kind of leading a team of federal officials and advisors. And so that bill has a much stronger preamble than the BC one, goes a bit further in some points. Similar strategy, a government has to create an action plan in partnership with Indigenous peoples, has to move forward on that, has a kind of a window on which to start working to bring all federal laws in compliance with UNDRIP. And so we'll see how that goes, but these are exciting times. But at the same time, there are all of these other challenges. that exists within the country too. But there is some significant movement on the UNDRIP front. The question, of course, is, and UNDRIP itself addresses these issues, but the question is, will governments in fact bring domestic law into compliance with UNDRIP as these statutes suggest they should? And I've probably already gone over time without touching the first question. So again, perhaps I should follow up on that by email afterwards.
Yeah, thank you. Thank you, Brad. That's great. I mean, we can continue like chatting even after the conference if we think that we have made good connection. That's exactly the case. Okay. Thank you a lot. And let's move on with the next presentation. We have Kathleen Mahoney with a presentation titled "What is Indigenous Law and Why it is Important?" I really look forward to this presentation. So the floor is yours, Kathleen.
I'm going to quickly try to share your PowerPoint now, Kathleen.
Sure, yeah.
And I'll do share sound. So if we can hear you, excellent. If not, then I'll undo it and redo it, okay? Okay.
So you're trying the video thing?
Can you hear me?
Yes, I think we should be good then.
Wonderful.
Okay, great.
Wonderful. Well, I'll introduce myself. My name is Kathleen Mahoney. I'm a professor of law at the University of Calgary. My areas of expertise are human rights internationally and domestically. I also teach Indigenous legal principles and law, and I teach the residential school settlement agreement and the Indigenous principles underlying that agreement. I've spoken about that to this conference in the past. And as one of the architects of the Truth Commission in Canada, some of the things that Brad spoke about, I'm sure are on your minds. I've watched the chat and I'd be happy to answer questions some of you may have when my presentation is concluded. But before I begin, next slide, please.
It's good to hear you again.
Thank you, Laura. Thank you, Laura. Could I have the next slide, please?
Shut up now.
So before I begin, I would acknowledge to you that I'm speaking from the city of Vancouver, and Vancouver exists on the unceded territory of the Coast Salish peoples, including the territories of the Musqueam, the Squamish, and the Tsleil-Waututh nations, which have been living and working on this land from time immemorial. Vancouver and 95% of British Columbia are on unceded First Nation lands. I'd also like to acknowledge Laura and Katie and Luke and all the others on your team for all your work in putting together this conference under these circumstances, which aren't ideal. And thank you again for the invitation to speak to you today. Next slide, please. So what I hope to do in this presentation is give you just a snapshot of Indigenous legal systems, because we don't have time. I could spend the whole time on any one of the ones I'm going to talk about today, but I just want to give you a bit of an inkling of what Indigenous legal systems exist in Canada, legal systems that have existed for thousands of years and are now beginning to be recognized, relatively speaking, by the mainstream legal system. And Brad has touched a bit on a few of those things. There is a distinction that must be made between Aboriginal law, which is law developed under the Canadian system, and Indigenous law, which are laws developed by Indigenous peoples themselves. These kinds of Indigenous law principles, most relevant to this conference, are grounded in ecological integrity and respect for the land. All those elements come up in all of the systems of Indigenous law. And the video I'm going to show you at the end of my presentation shows you a contemporary application of that notion. Now, Indigenous legal principles are also important for achieving reconciliation and transformative change. And the recognition, I hope to impress upon you, of Indigenous laws by courts and governments in Canada, as well as in the international jurisdictions, would add to the sum of the justice in the world, and particularly to the survival of the planet. Next. So The diversity of Indigenous law is exemplified by the samples I'm going to show you. And those are the Mi'kmaq, the Haudenosaunee, Anishinaabeg, the Carrier, the Nishka, the Inuit, and Métis. Next. Now I'm going to have to ask you, how do I get rid of the pictures on the right-hand side, because they're interfering with the slide, so I can't see the entire slide.
The pictures of us?
Yeah.
That go to your personal view. It should be in the upper right. Jeff is better with these instructions.
Okay.
But it's
okay,
your
great.
personal screen view.
Yeah.
And then you can minimize us, take us off completely, do whatever you want with us.
Okay. Okay, I want standard. No, that's still, oh.
You can do hide thumbnail video. It could be at the top of our images.
I see it says view and then standard side by side. I don't want side by side. I want just the
If you go side by side speaker, that you'll be able to then push.
Oh, okay, great. Okay, I've done it. Okay, thank you. Thank you very much. Okay, so before we get into the specifics, there's some understandings that are important for understanding Indigenous law, some general understandings. And one of them is that culture and law are not frozen, they are living systems of a social order. And Indigenous laws must be understood in the context of their own cultural traditions. They, just like mainstream law, remain relevant by being reinterpreted and debated in contemporary terms. I mean, our laws are debated every day in courtrooms, and they change and they adapt to different contexts, and the same is true for Indigenous laws. So they deal with contemporary issues ranging from things such as computer technology, gender equality, family law, inheritance law, stem cell research, child welfare, and most importantly for our purposes, environmental protection. Next, please. Now, starting with Mi'kmaq law, the sources of Indigenous Mi'kmaq law are nature, natural law. These are conveyed through stories that are handed down from generation to generation. Customs that develop over time are sources of Mi'kmaq law. They have deliberative laws that result from meetings and councils, and some of those are positivistic laws that are written down. And also the sacred is an inspiration for Mi'kmaq law. Importantly, legal rights in the Mi'kmaq tradition are family-based. So even if a person moves away from their family territory, let's say moves to another country or another province, they can always return to their family's territory to exercise their Mi'kmaq rights to hunt and fish and any other rights associated with that territory. Community and spiritual leaders identify and proclaim what the laws are, and this is a source of active research now in Canada, particularly amongst graduate students. And a Grand Council deliberates and builds consensus through airing disagreements and developing solutions. So this notion of consensus is integral to enforcement of the law. Next, please. The Haudenosaunee legal traditions are exemplified by this illustration of the two-row wampum belt. I'll talk about that in the next slide. I'm gonna have to speed up the slides or I'm gonna go over time. The constitutional law of the Haudenosaunee people are symbolized as in the two-row wampum belt. This belt was created as a result of a peace and friendship treaty that was entered into with the Dutch and the Mohawk in 1613. And the two rows represent the intention of the legal agreement. One of the blue lines represents the canoe of the Haudenosaunee, their way of life, their laws, and their people's customs. And the other blue line represents the Dutch ships with their laws, religion, and people. So you notice those lines do not intersect. That symbolizes the fact that these were to remain in their peace and friendship, but separate and apart and be self-determining peoples. The quote that's often recited about this particular belt is that together we will travel in friendship and in peace forever, as long as the grass is green, as long as the water runs downhill, as long as the sun rises in the east and sets in the west, and as long as our Mother Earth will last. Next. Here's another example of Indigenous law represented symbolically in a belt. This is the Great Covenant Chain illustration. It symbolizes the famous Niagara Treaty and the Royal Proclamation of 1764. And that proclamation bound the British Crown to trade and to enter into mutually assisting agreements with the Iroquois and the Haudenosaunee, and later to other tribes and government entities. The Great Law of Peace is also part of the Haudenosaunee Constitution. Now, the Anishinaabeg legal traditions are different again. Next slide. Anishinaabeg people are also known as Odawa, Potawatomi, Ojibwe, or Soto. They organized themselves into clans in a loose confederacy called the Council of the Three Fires. Clan systems regulate behavior. They resolve disputes and allocate resources such as hunting and fishing grounds and food gathering sites and location of villages. The laws are based on a totem system where each family has a totem that determines identity. It determines reciprocal obligations and conservation practices. These totems also reduce conflict and ensure equality in food supplies. Anishinaabe principles are very important. One of the most important is that process is critical. The Anishinaabe people believe that if the proper legal process is followed, the outcome will be correct. Duties are also as important as rights under Anishinaabe principles, so that when a right is invaded, the question becomes what duty has been violated and what needs to be done to heal the community as a whole. So the focus is not totally on the person that's violated the law. Land stewardships concepts are embedded in legal principles. Following the creator's principles are thought to lead to a happy afterlife. Rituals ratify legal relationships through ceremony. Ceremony is very important for ratification. And living by principles of stewardship of the land, loyalty, patience, and bravery are things that are praised and honored in the community. Next. Here's an illustration of the importance of ceremony in a contemporary way. In this photograph is the former National Chief Phil Fontaine, who many of you are familiar with, and former Justice of the Supreme Court of Canada, Frank Akabuchi. Notice Justice Akabuchi is holding a feather. This ceremony occurred in a lodge in the Kenora area to consecrate the Indian residential school negotiations. This was prior to them starting. Justice Akabuchi was brought into the lodge on the shoulders of women, and dancing and prayers followed, the smoking of a ceremonial pipe. After this ceremony, people in attendance went to the National Chief's own Ojibwe community, subjected themselves to questions and debating from the people of the community, and also then celebrated in a feast. So that underscores the importance of ceremony in a very contemporary example. Next slide. I also wanted to show you the importance of process in the Anishinaabe tradition, and this is not uncommon in other traditions as well, but this is an example of how, going way back in time, serious decisions were made when there was a threat to the community. And back in the early days when starvation was a huge problem, often people would lose their minds and they would become cannibalistic. So there's several stories that have evolved from that describe what process should be followed when that happens. And the first step was to wait, observe, and collect information about the threat. Then there was a consultation process with the community consisting of elders, family members of the person who was threatening the community. And then the next step was to help the person, if at all possible, who is in trouble. And if that step failed for any particular reasons, that threat would have to be removed to protect others in the community. That threat or that removal could be everything from capital punishment or execution, I should say. The punishment wasn't part of it, or banishment from the community. And then that was followed up with a process of restoration or restorative justice, where the families, perhaps where this person had been removed, would be restored. So if it was somebody who had to be executed, for example, there would be, and some of the stories tell us, the replacement of that person with another child or another warrior or whoever it happened to be to fill that gap. And the community itself was invited to participate in this restoration. So these are examples of process. This is a current example of consultation. This is an Ojibwe community consulting on community health issues, for example, the very common way of solving local problems. Cree legal traditions are next. The Cree people shape their laws very connected to where they live, their geography. So there's basically two main groups of Cree people, the Plains Cree and the Woodland Cree. The Cree language is very important for Indigenous law because it encodes many legal principles. Overarching Cree law is natural law, laws of nature, in other words, which govern all relations. And the stories, these natural laws, as I mentioned earlier, are embedded in stories which explain the lessons that the natural world has taught the Cree people, and it facilitates order in their communities. Cree legal principles involve circles. Circles are sacred. They bring together people. They remind them of Mother Earth and the circle of life. Cree traditions can be concluded in circles, talking circles, healing circles, reconciliation circles, and consequences are decided in circles for breaches of Cree law, and they can be quite severe. They can require redress, reprisal, retribution, blame, and so on. So that's the way in which the laws are enforced, are through this circle approach. Here's an illustration, again, a contemporary illustration of a healing circle. Animal imagery is important in Cree law. Animals are regarded the same as persons, and they share human characteristics. Relationship with animals are considered to be the same as relationships with other humans, and the same legal rules apply. Restorative concepts play a large role, and this is particularly true when it comes to hunting. Respect for the animal which has given up its life for the nourishment and use by the people. Problem with this area of the law in many ways is that Canadian mainstream law creates many incongruities with Cree laws, and I don't have time to go into those right now, but it is a problem for sure. Next slide, please. The carrier people have a set of laws that overlap with others, but they're also different. They govern themselves around a house group with hereditary chiefs, subsidiary chiefs, and house members. The carrier people the area for carrier people is on the west coast of the country. A group of houses is a clan, and membership, and this is very important, is through matrilineal descent. These are matrilineal societies. Head chiefs come from each clan, and they act as judges when someone is accused of breaking the laws. And chiefs have dispute resolution powers. They can enforce the laws formally or informally. And we've seen those happen in recent conflicts with pipelines, for example. Potlatch laws are central to carrier culture. They dictate succession and inheritance. They deal with family law and resource management, territorial laws, again, dispute settlement, village governance. The conduct of women is controlled by law, and principles taught to children are also embedded in potlatch laws. Feasting, like the Anishinaabeg people, ceremony is very important, and feasting is part of the legal process. If there's a formal agreement entered into with another tribe or with the government of provincial or federal, the formal business takes place in the feasting hall. And once a legal agreement has been reached, it is sanctified by a feast to seal and validate the rights and obligations in that legal agreement. It is also sealed through the scanning of eagle down. And this symbolizes peace and forbearance, and it sanctions this sanctioning in this manner is an integral part of carrier law. Another important part of carrier law is the witnessing. Certain people in the tribe are designated as witnesses, and it's their responsibility to tell the story of these legal arrangements and agreements in gatherings. And those are part of the stories which then are handed down and repeated by others who are designated as witnesses. So this is how in the past those agreements were remembered, because this was largely an oral society. Individual conduct, again, we see overlap here. It's governed by respect, responsibility, balance, caring and sharing. All of those elements have equal weight and are to be followed at the same time. Animals and fish are to be treated respectfully, and if not, the belief system is that there will be repercussions, terrible repercussions. And stories that explain this, they talk about the disrespectful treatment of salmon, resulting in the salmon not returning and the people having a famine as a result. They analogize that to stories about the consequence of abusing one's wife. Next, please. So animals and fish have their own legal rules, and we see some interesting overlap perhaps with the New Zealand approach. Now we'll turn to the Nisga'a principles, which is a very contemporary example. Next. The law and governance of Nisga'a peoples, again, organized into clans, broken into house groups or wilps. Each wilp has a chief, their own territories, songs, dances, and traditions. They are matrilineal, matrilocal. Senior women make decisions on very important issues such as inheritance and family law. Each whip has an oral historian who describes all of the ancient history to up to date to contemporary times and records fishing sites, property rights, hunting territories, etc., and how those rights should be passed down within families. This ancient legal code guides social, economic, and political relationships. And these laws also, like the Mi'kmaq, connect people with their territories. Okay, next. Contemporary Nisga'a law is the Nisga'a Treaty that Brad referenced. They were given their own territory, as you can see on the map. They now have their own court system and statutory law governing marriage and divorce, resource use. And so we see these laws finding their way into written positivist legal form, and also a type of concurrent jurisdiction with federal and provincial laws. And in some areas, Nisga'a law prevails. So we see a multi-juridical system emerging in the Nisga'a example. Inuit legal traditions. Fundamental principles, again, we see this overlap of respecting others and caring for people, fostering good spirits, welcoming and being inclusive of other peoples, and providing for family and community as a collective responsibility. Next. The Nunavut Parliament is the contemporary example of Nunavut laws coming to life in a contemporary way. And we see the Nunavut Parliament having all of these jurisdictions, which are normal for governments to have. What's interesting, next slide, please, is that there's no political parties under the Nunavut government. So there's no partisan conflicts taking place. The cabinet governs by consensus. So people work together for a common cause. Their problem solving becomes creative and resourceful. Their philosophy of openness and acceptance and inclusivity, of course, supports that. Cooperation without barriers, sensitivity to difference, all of those things help to make the Nunavut government principles work. Next. I notice that passage of time is important here. So I'm going to skip over the Métis slides. So if you can go please through the Métis slides quickly. The one thing that I would say about Métis peoples is that they have codified laws. They were the earliest Indigenous group to do so. And that was generally to do with the buffalo hunt, where that was controlled in terms of preservation, in terms of methodology of the kill, in terms of respect for the buffalo. So in conclusion, then, I think what my presentation shows is that Indigenous laws have many rich and complex sources to resolve disputes. They include central components being the stewardship of the land and the environment, and also restorative justice. So we restore what we destroy, we restore what we take. Indigenous laws are legitimate. They have been around for thousands of years and they have worked. These societies could not have been sustained without law. And so that in and of itself is irrefutable evidence that they're legitimate and they work. The other point I think that comes clear in this is that the social cultural elite cannot be the only keepers of legal knowledge, that laws must reflect the cultures within which they operate. Otherwise, if a culture is deliberately excluded from the laws, respect for the law dies and chaos follows. What we're seeing in Canada right now, the burning of Catholic churches around the country, is an example of that. Legal traditions must be brought out of the past to increase their scope and vitality. And finally, Canada and the world could benefit from a multi-juridical legal system that incorporates Indigenous law. Now, I did have this video. I'm going to go 4 minutes over if we watch it. Is that okay? It's a 7-minute video. You would just have to paste it into the address bar on YouTube.
Yeah, sorry. I thought that the link was live. I apologize. Let me go here. Okay. And is the PowerPoint still up, or is it my shared screen, Jeff?
I would just highlight the address, put it in your address bar on Google, and it should come up on YouTube.
Yeah, but with my sharing screen, I shared your presentation and not my computer. So can you see the video right now?
No, I think you need to reshare.
Okay. All right, let me go back.
Click the
button. I think you need to share the Google Chrome page.
Exactly. Yeah. Okay, here we are.
Click the thing that says share your computer's audio.
Okay, so let me minimize everything in the back, maximize this.
We've always been told that water is life. We are who we are because of water. And one of the things that we keep coming back to is how do we want to do water governance in our territory?
Those stories really created law. They're a reference to how we as a people are meant to live on the land.
to protect water and land in our area. And this is a process I am happy to go through to learn how to frame stories and some dreams. There are some areas in our territory that have history and cultural values that we want to protect.
We have complex decision-making processes. We have complex forms of governance. It's relevant in today's legal context, and it has legitimacy. Talking about Indigenous laws, revitalizing these laws, has led to not only hope, but also trust within the community.
If you're going to be considering environmental law, you need to be in relationship with the land and with the water. And so it made a lot of sense when we were working with Alice and the Tsilhqot'in that we got to be in relationship with the land by spending about a month outside.
One of the first things that Alice taught Lindsay and I when we arrived was how to behave respectfully with some of the other beings on the land.
Our parents taught us to respect the land, the water, each individual animal, bird, fish, everything on earth has spirit, the rocks, the soil, the trees.
It's like another piece of me has come back, you know, a piece that has been lost. I've been like searching for my identity, I think, just as any young person who hasn't known their culture or their stories or their songs. Learning how to live within yourself, the laws that I've been learning, you know, like respect and sharing and forgiveness. We all have to go through our own reconciliation, I think, you know, with everything that we've lost. Having stories be sort of the format, because everybody's so familiar with stories and it's so fun. You know, you can laugh about some of them, and yeah, it's a good way to bring people together because we all have our own story.
What our interpretation as researchers on the story, talking about it with the elders and the technicians, getting the clarity and the affirmation of it, you know that it is law, that it's real, and the people in the room know that it is as well, and that's very powerful.
So the Relaw team met with elders, knowledge keepers, technicians, and community members on a regular and a regional basis. We got direction from the St'át'imc Chiefs Council to focus on water as the primary issue. The goal was to produce a policy document and the process provide opportunities for all St'át'imc citizens to be involved in determining how legal principles embedded in our stories can and should be used to make decisions.
All those other processes we've been going through are from the outside, like to help industry get on the ground, basically. The Relaw project is different because it's something for us, by us, that is grounded in who we are, and really trying to figure out how we can bring the knowledge of the land and the elders to the work we do every day and turn into something that the people can see themselves in and really empower the nation.
Having the opportunity to work for the Secwepemc Nation and experience Secwepemc law has allowed me to better understand and value the place and the people whose ancestors have governed the territory for thousands of years. Bringing people together and talking about the things that connect us, like language and law and our children, are creating these strong foundations for people to heal the relationships that have been created through oppression and the process of colonization.
I will
with this resurgence of Indigenous law, that connection comes back. Understanding that the political world, the legal world is bigger than these human-to-human relationships, but it extends to a relationship and a responsibility, an obligation to plants, animals, spiritual beings that we don't see on a daily basis.
We can't forget who we are as Dene, because this world needs to change, and it will change. And either we stay who we are as Dene or we forget. And I think the Relaw Project helps us remember who we are.
Okay, well, thank you for listening, and that's the end of my presentation.
Thanks a lot, Kathleen, for this amazing presentation and for this video. It was super interesting, especially for the perspectives that we don't have in westernized society. And I think it's so important to recognize that legal pluralism exists, and like different nations and different way of thinking coexist in the same borders. We now move on to the next presentation, which is Matteo Bruno Scannapieco, from Theocracy to the Rule of One is One, Populist Echoes in Italy Today. So the floor is yours. If you, I don't know if you have to share a presentation.
Yes, here we go.
Sure. Okay.
So,
Thanks.
good evening, everyone. And thank you very much to the chair who gave me the floor. And thank you very much for Professor Westron. Thank you very much to Katie and to everyone who made also this year possible to have this kind of conference. Well, speaking after Professor, it's very difficult because the presentation that was just right before me was very astonishing for everyone who is a student in comparative law, who does research in this area of law. So you can see my screen, right?
Mm-hmm.
Okay. So today I wanted to talk to you about something related to populism. Even if my main area of research is related to comparative law and to civil law, as at the course of professor I'm working with Virginia Zambrano, there are now some students who have sociological background. I thought that it would have been very important to broaden our area of research and having a look at also the problems that we have in the society before coming to legal change that we might want to the territory where we belong. And I realized that regarding to the problem of populism, nowadays in Italy, we are facing a really strange situation because we are used normally to think about populism as only as a fascist movement or other kind of extremist movements. But nowadays in Italy, we are having a technocracy, which is a form of government where there are some technicians which have not been elected by the people who are running the country. And in just a short term of years, in even less than 10 years, it is the second time in our Italian history, just 3 times we had this situation. It's just the second time that we have this kind of situation. So I wanted to ask myself, technocracy and populism are related? what is happening in Italy nowadays? So from technocracy to the rule of one is one, populist equals in Italy today. Here we have some photos that we're going to analyze later. We have some politicians in Italy, which is Matteo Salvini, which is the leader of movement Lega, which was a former secessionist movement. We have Beppe Grillo, who was a comedian that started his own movement, that is Movimento 5 Stelle, Movement 5 Star. And of course, as you can see, we have a different, even in the way of dressing and communicating. We have Mario Draghi and Mario Monti, who represents in this moment the two era of technocracy that we had in Italy. One was a former convention of the European Union. Mario Draghi, which is the actual prime minister in Italy, was the former chief of the Bank of Europe. So the reason behind this research proposal is firstly understand the cultural change before legal change in a sociological perspective, understand the power of masses and the way that the parties are trying to find in order to gain control of them, and highlighting also the link that we have between the behavioral studies of people, social media, and politics. We will analyze Facebook algorithm and also the system that Salvini invented, which we call in Italy la bestia, the beast. And also a problem that we have in dividing the voters thanks to this kind of extremism, that is targeting and polarizing the differences between the voters. That is, all these kind of aspects are having the aim of dismantle the culture of democratic representative system. So what do we mean by technocracy? If populism is something that we all know is very common in many states, the term technocracy that comes from techne and kratos from Greek means the government or control of society or industry by an elite of technical experts. This kind of systems explicitly contrast with representative democracy, because even though we have some technicians, some people that have degrees, have a PhD, or are very keen on their subject, we have the problem that we have decision makers that are selected on the basis of specialized knowledge and performance rather than political affiliation or parliamentary skills. So we have no election. We just try to choose the best one, the one who has the better skills. So the term technocracy was originally used to signify the application of the scientific method to solving social problems, and then it turned into a political form that we had now in Italy lately, which was why technocracy can be harmful for democracy, because it confiscates democracy in the name of economic and financial imperatives disguised as natural law. When we have technocracy, it happened in Italy twice, both with Mario Monti, both with Mario Draghi. People try to find the solution to all the problem of the country, just giving the keys of the country to these technicians. So thinking that this will be the problem, and so having a bad judgment on the democratical system that they had until that time. So it is harmful for the democracy because of the following assumption. Firstly, because the development of science technology makes politics superfluous. So we don't need politics. The rationality of the expert is not limited as it is the one of the ordinary citizen. So they have like a natural gift to guide people. And the supposed moral superiority of the technocrat, who will be immune to the corruption and the ambition of personal power, of course, causes problems for the democracy. But the worst problem is that with this kind of government, there is an objectivistic conception of common good. There is just one common good. There is not the dialogue between different parties and different phases of the society. There is just one real truth, one common good. That so is exempted from doubt and public debate. The common good is the science. There is no room for any debate. So in this sense, technocracy is the antithesis of democracy, which does not advance claims of truth or justice, but relies on respect for the dignity and freedom of every individual. Technocracy, on the other hand, is kind of another phase of the populism, because it forms a power administration in which politicians may appear in the leading front, but they are not the one who are in charge. So, considering our recent past, as I told you, after the European economical crisis that we had in 2010 and so on, after Prime Minister Silvio Berlusconi had to resign from his post, we had this first technocratical government, which was former ambassador, former professor, and this kind of government, in order to fulfill the need of European Union about financial problems that we had in Italy and so on, brought in Italy an austerity politic that in the first instance was well welcomed by Italy, because it was the way of escaping the big problems that we had with Europe, with the spread and the fear that we had to have an economical crisis such as the one that they had in Greece. But then, after the first measure that government Monti adopted, there was a populist movement that started to gaining more and more power. And this party was the movement 5 Star, Movimento 5 Stelle. In fact, even though this movement was founded way back before this government, this technocratical government, after the fall of this government Monti, it was the first time that this strong populistic movement presented himself at elections, and they had a very good result. Why? Because there was this need of coming back to the people. What is the 5 Star movement? Even if it is nowadays a party, started as a movement on 4 October 2009 by Beppe Grillo, which is a comedian and blogger, and Gianroberto Casaleggio, who was a web strategist. So we had these two people who were expert in communication. And this party had always been considered a populist, as an anti-establishment, as environmentalist, anti-immigration. And even as if he claimed always himself as a movement, he started from having meetings and meetups in public places. And then step by step, he started having firstly some of his representatives in local governments. And then they had also a representative in the national government. These 5 Star are their 5 key issues that are public water, sustainable transport, sustainable development, right to internet access, and environmentalism. The party also advocates e-democracy, direct democracy, the principle of zero-cost politics. The problem here is the problem with e-democracy, and this is why I'm really afraid of what might happen in Italy. In fact, thanks to the platform that that Beppe Grillo and the movement 5 Star created, this movement had a way to connect directly with all the voters and finding a way to have an e-democracy where every voter, at least even not in a certified way, could decide, like on a referendum on Facebook, the future of this movement. And when this movement became one of the majority party in Italy, also the future of the country. So they started, as I said, with this tsunami tour that was meeting people in public places step by step. And then they ended up in 2019 choosing also the first prime minister in Italy, that was Professor Giuseppe Conte. As I told you, in 2016, they created the Russo platform, and the basic rule of this Rousseau platform is the rule that one is one. What does it mean this one is one? It means that the vote of anyone is the same of any one other, which is a golden principle of democracy. But the problem is also that everyone can be elected, or anyone has the same technical skills of everyone. So even though it is a principle that is the same of democracy, this led the movement, the five-star movement at their first election, which was right after Monti, to elect people who didn't have any kind of education, and that every time they were interviewed, they couldn't talk, they had to wait from the directive directly from the movement. So it's very strange, but it seemed to live like in a movie, like in a dystopic movie, where everything was decided from the network, from internet. Let's have some examples of the way the social media that movement 5-star worked and how they gained consensus through the years. The way social media worked, and social media is very important for politics nowadays in Italy, was having this kind of communication. They played a leading role gaining consensus and lead the masses. So, for example, apart from the official blog, they made wide use of social media such as Facebook, spreading out with many satellite pages, so not only with the main page of the movement 5-star, having posts such this one. So very strong post, very aggressive post that always has this cubital wording, asking all the voters, all the followers to share. So the aim of this was to post easy and direct message that hit the emotion of the Facebook user, inviting him to share the message. This was what happened while the movement 5-star was at the opposition. But then in the political election of 4 March 2018, the movement was the first Italian political party, exceeding 32% of the votes. So from the opposition, they became the majority. And the interesting fact is that the prime minister was decided by a deal cut by the movement 5-star and also by the Lega, which is another populist party that had secession origins. And the person which they chose as the prime minister was Giuseppe Conte, that presented himself as people advocate. So as they were now in the majority, they had to change the way of communicating, and Giuseppe Conte chose as his spokesman Rocco Casalino, that was an engineer, that was a former competitor of Big Brother, that after the Big Brother made some studies about communication and use of communication in politics. The interesting is that Salvini, that is the representative of Lega Nord, that is another populist party, had to, in order to have the same numbers of voters of the movement 5-stars, chose to build himself his communicative system. So he had to put himself on the safe path of the movement 5-star, and created this social media strategy that was called the Beast, that was developed for Matteo Salvini accounts by journalists and communication experts. According to some press agencies, in order to have this kind of success, the league's leader will need to be using an innovative tool that allows his social media, Luca Morisi, to get instant feedback about the buzz and sentiment score generated by the thousands of interactions that Salvini's tweets get daily, in order to adjust the strategy and please his fan. So basically, every time people were tweeting or posting something on Facebook, this kind of system was registering what people, the majority of people, was thinking, and having in consideration these tweets, Salvini was trying to change his way of presenting himself and his way of doing politics. So there was no longer an idea behind the party, but there was just the way to please the future voters. And in fact, we have here some very strange but effective way of communicating with Salvini, such as dressing like a policeman or any or a guard coast or any other kind of politic entity of public entity. And also there were kind of challenges that he made to his voters. For example, sharing all these posts more possible in order to give them some rewards, such as having a personal private call with him and so on. You may think that everything such as this one may be very strange, but the aim behind this thing is very important. In fact, also during the pandemics, Facebook in Italy was used as one of the principal way of communicating not only the changes and the problems that we were facing, but also sometimes was the way of communicating the legal changes that we were going to face from Saturday to Monday. So we had very big problems because even the Premier Giuseppe Conte was having this kind of use of Facebook, of targeting users and voters, but also using Facebook as an official channel. Once it was the television, the official channel to, and the television in such a way could have been controlled, but Facebook is impossible to control, so was targeting people and communicating in this way. But the problem here with Facebook was very well explained in a documentary that is on Netflix that is called The Social Dilemma. The way the algorithm of Facebook, Twitter, Instagram, and so on works is making very problems with politics because thanks to this algorithm, everyone is targeted on the basis of his preferences, and he can see on his social media only the things that he likes. So if sometimes he, for example, shares a post of Movement 5 Star or Salvini, he will always see only posts of this particular party. So he will never broaden his mind, and he will be bombed on a truth that it will be partial. It will not have the plurality of information. And in this way, there will be a problem in having more and more conflict between people that will have everyone their personal kind of truth. And so, thanks to the algorithm of Facebook, every party that is a lot of money can just spend it on Facebook or any other social media and create this different reality to every voter and every user that they want to reach. Political propaganda, anyway, is not something that is new. It has always been the fuel for totalitarian regime whose backbone was populism. Here we have some example of the Italian political propaganda during fascism. But we were under a totalitarian regime, so it was understandable. Now, even though we are not under a totalitarian regime, we are forced anyway, without knowing, to see just one real truth and not all the other differences and all the pluralism that we had to have in order to expand our thoughts. In fact, propaganda helped controlling masses yesterday. This is the march on Rome. It was march where fascism finally made a clear and strong statement in trying to rule the country. And in March, you know, people unite themselves under one idea, but sometimes they don't even know what they're marching for. But being in the mass helps them in being like in a pack of wolves and going all in the same direction. But even today, we also have this march that start from the propaganda, that start from the social media. We had the Movement 5 Star who marched on Rome, but also lately in USA, we had this march after the elections that started on social media and had this wide effect in the country. Nowadays, what is the situation? Now we are back to technocracy because the Prime Minister, after the problems that we had with COVID, is Mario Monti. And even though if he's a technocrat, he has been very well known also, very well welcomed also by the public opinion. This is a fun word that is written taking into consideration a strong affirmation by Draghi. But the problem is that now that there is this technocracy, we are seeing that the possible result of next elections, the actual consensus that the party who are in Italy are having now, are only on the parties which are very extremist, such as Fratelli d'Italia and Lega and Movement 5 Star. This is Fratelli d'Italia, which is a movement that traces back his idea from Movimento Sociale Italiano, which also was made up by the people who escaped from the Republic of Salò, so who were the former fascism when Italy was divided into two parts after the arrival of the Americans. So maybe we will go after this technocracy back to the past. Maybe we might go back to secession with Salvini, which now is called Lega, but once was called League North, and we will be back as this Italy of year 1000. Or maybe we will have a step to the future of e-democracy, just having direct vote directly from Facebook. In any way, if in a way or another, in technocracy or direct democracy, we have this example of what direct democracy brought us as one of their best results. Jesus or Barabba, the crowd chose Barabba directly. So having this kind of direct democracy without any intermediate party, such as the representative. So thank you for your attention, and I'm really looking forward to listen to the next presentation.
Thanks a lot for this great presentation. Of course, me being Italian, I know very well these problems, yes. But I think that you gave like a very thorough overview, and that everybody has understood what we have been going through in the past like years, decades. But I do think that like this thing about social media is scary, and it can draw parallelism to other countries which are undergoing like the same situation. We do have a question on the chat from Katie. She's asking if the populism in Italy is rooted in racism, and is she asking if it's connected to the influx of refugees. And she said that in the US it is the tie that binds this kind of movement. And she's also asking what is the position of the populists on environmental care.
Okay. Well, regarding to the first question, so with refugees, of course, having an enemy is a way of unifying people. I am from southern Italy. Once it was from the north, it was people coming from south emigrating to the north. Now, even people from the south, all the Italians have been unified by this bond against people who are coming here. But the problem is that the racism, I think, and here we have also some Italians who can correct me or give their thoughts on it. In Italy, the kind of racism that we have is more an economical racism, more than based on the color skin or on the tradition or any other things, because Italians tend to have this kind of idea that people who are coming from Africa, from China, etc., are coming here to try to take their job, or anyway to try to change their custom and so on. So of course, the influx of refugees was also at the very beginning a strong binding element between those two parties who were the populist party who were at the majority, Lega Nord and Movement 5 Star. But at some point, exactly on the refugees, this alliance was broken, because this Movement 5 Stars, having this Premier Conte, started to have a more balanced approach, starting to have also a link with left-wing parties. In fact, after Salvini, they made a new coalition with a left, center left wing party. And also about environmental care was one and is one of the main focus of movement 5 Star, because Beppe Grillo, when he was a comedian, because the strange thing for me is talking about this topic. When I wrote the abstract, it seems to me like talking about a movie, a series that there is on Netflix. But this the reality. This comedian was doing shows on ecological aspect, on way of having renewable energy. So for the movement 5 Star, they are using this aspect very strongly. So also the environmental care is seen as something populist, in fact, but it's good for all of us. In fact, with the latest government, they created a specific ministry on environmental issues for the renewable of Italian technology on renewable matter. And it was very wanted from Movement 5 Star. So that was this problem. And I see, so it's the problem is really, these type beings in the position of the, so this was for Kathleen. Wasn't there an Afro-Italian member of parliament who was called some very ugly name because of her race? Yes, Cecilia Chienge, but as I told you, in Lega Nord, that is this party that is now very strong in Italy. There was also one person from that was from Africa that moved from Italy, from Africa to Italy, that was presented as a candidate of Lega Nord. So yes, there was with Cecile Chienge, and there are still now these kind of problems. And one of the main problems that we have now, because differently from the US, we have the jus sanguinis instead of jus soli. And that is also a matter that has to be discussed in our parliament, because there are some proposals of changing this law in Italy. We have, as we are a country of immigrants, basically, if you have an Italian who moved 3 generations ago in Argentina, but has Italian roots, he can claim Italian citizenship. If you have someone who is born in Italy, but he has not Italian roots, because their parents moved from Africa, China, whatever, you cannot claim directly the citizenship because of being just considering the place where you are born. But they are working of a mixed way that is called jus culture, that is mixing the place where someone is born, but more the place where someone is grown. So they people who is not born in Italy but has lived in Italy for a certain period, for certain years, have to have an exam on Italian history, etc., in order to gain the citizenship. But it is a very hard point, because we have football players who are coming to play in Italy and they have Italian roots. They are sometimes also they pay for the Italian exam, and then this is the way coming to Italy to have the European passport. So it is something that has to be faced and reworked, I think.
Yeah, the trend this is so wrong, because like, you know, you have people like they have to wait until they are 18 years old to have the passport and be able to travel, and they are like Italian as me.
Yes.
Yeah, that's very shameful.
This is a problem with healthcare, with university, with everything, because we have public healthcare, but you know.
Yeah, maybe Donald wanted to say something. If I see that he has raised his hand. No? Okay, so we can move on.
I just want to mark how many ideas you have stimulated in me and the importance of this topic. But is there any evidence in parts of Europe there were American right-wing people funding and trying to organize the right-wing populist movement? Is any of that in Italy? There's this guy, Steve Bannon, was going around holding meetings. So that's just one of many questions I'd like to talk to you about. I had no idea of this twist in the Italian
It's a
story.
movie. When I wrote it, I was not believing what I was writing because it seems
Excuse me. By the way, Don, you asked me a question yesterday, and I wanted to tell you that we started operating as part of various groups in the 70s. We were not having our own sessions, but we met with other groups, and we just had a small portion. We were just inserted in other people's programs before we had our own program, okay? So it's been a very, very long time. Okay, I'm sorry, it's just I heard your voice, and I thought I'd answer what you asked me yesterday. I would like to go on and do the next presentation to be sure that we have time for the closing words with Virginia. Okay? Can still continue to chat after.
Yes.
Sure. So let's move to our last presentation of the conference, which is Rose Dyson, Digital Devices, Populism and White Supremacy. The floor is yours, Rose. So if you want to introduce yourself, thanks.
Thank you. I'll just call up my PowerPoint here. Okay, well, now just a second. Well, first of all, thank you for still being here for the final presentation. I also want to thank the organizers for this opportunity to present my perspective on the mass media issues, Laura, Jeff, and Katie, and also for their help in so many different ways. And I should start by acknowledging that I'm talking to you from from Turtle Island, the traditional Indigenous name for Canada, and on or near the traditional territories of the Mississaugas of the Credit First Nation. So I appreciated the last talk, Mateo's, very much, and your emphasis on social media and how it influences the elections. E-democracy is an interesting new term that I hadn't heard before. And of course, you remind me of something that Marcia McLuhan has always said, that technology is never neutral. It has a way of enveloping us in man-made structures that take us further and further away from environmental concerns. And also, you made reference to the documentary Social Dilemma, rather. I brought that up following a presentation this morning, and I agree with you. It's very important and instructive as to just how social media does work. So I am going to talk today about one aspect of a book I just had published earlier this year titled Mind Abuse, Media Violence, and Its a Threat to Democracy. It's an update of one I had published 20 years ago based on my doctoral thesis finished at the University of Toronto's Ontario Institute for Studies and Education. And that book, I varied the subtitle, the first one from Media Violence in an Information Age to Media Violence and Its Threat to Democracy, because I believe that the problem has become so much worse. And of course, there were a number of different aspects in the book I could have talked about, like the research findings and how different disciplines have handled the topic over the years. Colin, in his own presentation, made some pointed out that on how the tobacco companies fudge the findings on smoking and how it causes cancer, and how much research depends on money being provided by whom, what questions are being asked, and what the purpose of the research is, and how we're seeing some of the same kinds of vested interests creating doubt about climate change. And I'm quite familiar with the process because I've observed it over a period of about 30 years now, and how it applies to media violence issues. I could also have talked about education, as Dawn did the other day, but on the subject of education, I think one has to first sort of define where who are the most influential educators today. I happen to be among those who believe that they're no longer the teachers in the formal institutions and parents and religious leaders. They increasingly are large media corporations who, as George Gerbner used to say, have a great deal to sell and very little to tell. But what I've chosen to do is talk about the most profitable aspects of popular culture that also happen to be some of the most harmful, according to the research that I've tracked over the years, and that's first-person shooter video games. Now, unbridled, and I've got the problem of all these pictures clouding my copy as well, but I can't remember how I'm supposed to get rid of it. Well, anyway, unbridled profit has overridden and dismantled checks and balances on the use of media in a number of ways. I really do have to get rid of these little boxes.
Go to view where it says view. You can have an option for different kinds of viewing, and put it in the one that says speaker.
Where is the view? Where is that box?
Top right corner. It's a little above where you see everybody's pictures, probably.
Okay.
And it says view. It's a little box.
Hide names of hide video panel.
Yeah, try doing that.
Oh, good. Okay. So unbridled profit has overridden and dismantled checks and balances on media use in a number of ways. The seeds for the democratic crisis we now face were planted in about 1987, when the FCC, the U.S. broadcast regulator, eliminated its fairness doctrine, which required broadcasters to present contrasting views in airtime discussions of controversial public issues. And the decision opened the way for the first generation of right-wing talk radio. Now I can't. Oh, there. The internet, which has never been subject to any kind of content rules, either for news or entertainment purposes, followed the lead of what radio and television started, catering to a vast audience and advertising base with increasingly angry political indoctrination packaged in news and performed as entertainment. And media literacy teachers often talk about these trends with using terms like infotainment or edutainment. The boundaries between the different forms of media have been blurred and continue to be obscured in many different ways. And so this paved the way for the abusive internet practices unfolding around the world today, whether we're talking about political trends, the sexual exploitation of children, or the explosive growth of video templates for mass murders. Online computer gaming fuels populism, undermines democracy, and has led to the rise of the alt-right, comprised predominantly of angry, anti-Semitic, anti-immigrant, Islamophobic, sexist, and racist white men. This trend is threatening political stability on a global basis. The threat they pose on Facebook was underscored on March 15th in 2019, when a racist gunman killed 50 people at 2 mosques in New Zealand, using the platform to post a live video of the attack, widely shared on YouTube. This massacre led to attacks on Sri Lankan Christian churches and a synagogue in California, and announced retaliation. In Canada, in April of 2020, the worst mass murder ever committed in this country occurred in Nova Scotia when 22 people were killed. And every day we hear of more shootings or knife stabbings. But calls for prevention that have led to little more than a familiar round of the blame game. In the U.S., it seems that the Republicans tend to blame video games when these are mentioned at all, not guns, while most media pundits still cling to the notion of no conclusive evidence of harmful effects. In Canada, the problem until very recently, although video games are not included in any proposed legislation yet, the problem is ignored entirely. Although a public inquiry was called into the Nova Scotia massacre and domestic violence is among the issues being examined, despite the remarkable similarity between the killer's rampage of stealing cars and murdering policemen in ways that mirror the playbook for the Grand Theft Auto video game series, it has not been reported as a part of the investigation. The growing mayhem has resulted in the explosive growth in grief counseling and hand-wringing over the need to address rising levels of mental illness. But the predominant emphasis remains firmly on guns, poverty, drugs, joblessness, and the need for better policing. Certainly, these are all very important components of what has to be done to address the problem. But as former Toronto Police Chief Mark Saunders has pointed out, what is necessary is better responses to 80% of the calls received by police, which come from the mentally ill. And rarely is evidence of rising mental illness accelerated since the COVID lockdown by popular culture and internet addictions even acknowledged, although there have been several newspaper reports on that in the Globe and Mail since the pandemic came upon us. Common sense alone indicates that the cultural environment is an inevitable factor in the values and norms adopted by the young. When 17-year-old Jonathan Davis, an innocent bystander, was shot and killed in September of 2019 in Malton, Ontario, the motive for the gunfire, as reported in the Toronto Star, was bad blood sparked by a rap video recorded earlier in the week in the low-income complex. To overlook the impact of violent entertainment in this case alone, in my view, amounts to willful blindness. So what exactly is helping to fuel this deadly social and cultural virus? The New Zealand gunman wrote that the video game Spyro the Dragon 3 taught him ethno-nationalism, and Fortnite trained him to be a killer. Fortnite now rakes in around $250 million US per year as the most popular online first-person shooter video game in the world. The game has led to esport as the young generation's principal collective pastime. Some earn huge salaries as professional gamers, bypassing more traditional career choices. This trend has been enthusiastically embraced by universities all over the world, which now offer courses in esport. According to the Globe and Mail, an estimated 23 million people in Canada alone identify as gamers. And since the COVID pandemic, overall gaming has gotten a further boost from the lockdown. In Asian countries, over 1 billion people identify as gamers, where esport is reportedly 6 times more popular than it is in North America. Numerous studies over the years have warned us that the obsessive gaming leads to health problems from lack of physical activity, addiction, and distorted mindsets. Gaming provides particularly fertile soil for sowing the seeds of resentment that grow into hate. News coverage indicates that white supremacists use social media in ways that slowly habituate potential converts to hate. Recruiters don't wait for targets to find them. They go to where the targets are. They stage seemingly casual conversations about race and identity in spaces where disaffected, vulnerable, adolescent white males tend to hang out. A gradual normalization of racist rhetoric is achieved. And while video gaming communities are not the only social media platforms where online recruiting conversations take place, they make for an ideal venue. And why? The thematic material in first-person shooter video games involves a comforting narrative of invasion of our spaces from people of color, feminists, and immigrants, with violent elimination the inevitable solution. It fosters an us versus them mentality, and this helps to create a politics of entitlement and resentment organized around race, religion, and misogyny. On one white nationalist message board called Stormfront, participants debate which mainstream game releases are most amenable to white power ideology. Some have taken to creating white supremacist games of their own. And it should come as no surprise to anyone that in his testimony at the trial of Alex Minassian, who left 10 people dead and 16 others injured in a van attack on Yonge Street in Toronto in April of 2018, defense psychiatrist Alexander Westphal compared it to the disassociative quality of someone playing a video game. And despite the enormous popularity and profitability of the video game industry, the implications and threat posed to global stability are still largely ignored, sadly, by many educators and health providers as well as policymakers. The global market for video games is now larger than that for movies and music combined. In fact, video games are widely estimated to offer some of the best investment stock options on the market available because, like tobacco, they are so addictive. Rampage, which followed the real-life massacre at the Virginia Tech campus in 2007, involved examples of games that have ushered in a new era of mass homicides worldwide in recent decades. Grand Theft Auto 5, a game laced with pornography, which involves the killing of prostitutes, in which you cannot play the good guy because the entire premise is based on criminal behavior alone, made more money in 2013 than the entire global music industry. U.S. Lieutenant Colonel David Grossman's 5 books on the subject, including his most recent, Assassination Generation, Video Games, Aggression, and the Psychology of Killing, which came out in 2016, they all help to explain why so many children die in senseless school shootings year after year. Grossman says that despite historic engagement in violence and war, people have an innate aversion to killing one another. To overcome this reluctance on the battlefield, psychological conditioning has been introduced into military training based on the stimulus response reward techniques pioneered by psychologist B.F. Skinner. Interactive first-person shooter video games have proven especially useful for this purpose. They help troops turn off the safety valve to avoid killing, but this is done in very strict, controlled circumstances. What the video game industry is doing is indiscriminately marketing these games to the youngest, most vulnerable people on the planet with no regard for the consequences. None of the safeguards which are required in the military are available in the video arcade or the home recreation room. Essentially, millions of players are being taught from an early age that killing is fun. This is dangerous and dysfunctional play. The interactive engagement involved rewards players with points for blowing off the heads of as many virtual enemies as possible. By 2016, a total of 23 multiple homicides were committed in a school by children under the age of 18 alone. They began in Paducah, Kentucky in 1975 and have been growing in frequency ever since. This coincided with the arrival on the market of interactive video games. The misleading classification criteria developed by the video game industry, especially the mature category, is like a magnet for teenagers. Children are drawn to imitate powerful people in their environments. We call it social learning. Movies and video games which glorify violence give them powerful, highly desirable, violent role models. Children around 8 years of age have difficulty separating reality from fiction. And among the pathologies developed from consumption of violent entertainment, they learn early that we live in a cruel, mean, and violent world. One result of such constant exposure to death and destruction is what George Gerbner called the mean world syndrome, or media violence being a hidden curriculum, and Grossman calls it acquired violence immune deficiency syndrome.
Excuse me, Rose, I think we should close soon, because I don't want to conflict with Virginia coming in for the close of the conference. Okay.
Well, I don't have too many slides left. I just got one or two more. Report.
Okay, all right. But
Okay.
I'm just concerned with the conflict of timing, that's all.
Okay, reports from parents of killers frequently point to an obsession with computer games. Some have paid the ultimate price and been murdered by their own children when they tried to take the games away. In the case of the Sandy Hook massacre, the killer had shot his mother before proceeding to the school, and there were a whole bunch of those videos left in his home. At times, there have been accounts given by the killers themselves who have survived their rampages. One in Kentucky, in California in 2014, all started at the age of 6 when the kid got his first video game played, and then Nintendo 64, I think it was, followed by PlayStation 2 at the age of 10, and then as a teenager become more and more obsessed with this until his day of retribution in adulthood, where he killed 6 people and wounded 13 more. The 2015 UN report on cyber violence against women and girls, a wake-up call, highlights the widespread representation of violence against women in video games and social media, all of which are becoming increasingly realistic. Periodically, it is reported on how women campaigning against the proliferation of violent video games find it necessary to hire bodyguards to accompany them on their speaking engagements. And this fall, we had a report in the New York Times from Christophe, who indicated that Pornhub, based in Montreal, and one of the most popular porn sites in the world, is the 10th most influential website in the world, and has the 3rd largest impact on society in general after Facebook and Google. And Chris Hedges, in his books, has pointed out how the whole world has become pornified.
Please.
Okay, all right. And then we have the influence of writers who told us about how this impacts on the development of terrorists, the killing game. Mark Bowery at U of Ottawa talks about that, and so on. Brain scans have indicated difficulties with all of this, and so on. There are a number of different organizations that have been developed to combat this. ACIT, Anti-Child Exploitation on the Internet team in Canada, is one of them. I work with them. There's one at Stanford University School of Medicine, and so on. So clearly, this there's a need for regulation of this, and I think an international panel on the cultural environment would be useful, and in order for us to have a better chance at a peace, order, and justice and good government. So thank you. Sorry to take too long.
Yes, please, enough now, because I don't want to have Virginia join us and not being able to speak. However, I want to say something important. Before we pass on to the close of the conference, I want to express my thanks, my heartfelt thanks, for fixing everything that was more or less almost impossible to fix, for my inabilities, the technical inabilities of everyone, of Jeff. So please, everybody, clap for Jeff Garver, who has really been our savior throughout the conference.
Yay! Woo!
Look, let me just, I want to thank everybody before I turn this back to Laura for hanging in there. We had really good attendance. This went really as good as I thought it could. And a lot of that is because everybody hung in there, you know, worked the internet how we had to. And Laura, you know, I just want to recall again, we started learning about a really scary thing you went through, and to have you be able to join so soon after that scare, hang in there, you know, come through with the telephone, and thanks for your patience with that, and then and even have you do the presentation. It was great. Thanks so much to Katie as well, who was a little behind the scenes. She said she doesn't want to be called a co-organizer, but she is. So Katie, you're a co-organizer, whether you like it or not. Laura, back to you.
Everybody clap for Jeff, who was our savior, not only mine. I don't know anything about technical issues, but many other people had problems. Okay, so thank you again, Jeff.
Thank you, but I would say, Laura, thank you to you. You know, thank you, of course, to Jeff that organized this conference, overcoming the problem, the technical problem, and all this kind of terrible situation. And yes, but thank you to you, Laura, that you are really the soul of this group. Really the soul.
Okay, Virginia, it's wonderful of you to be here at this time, and I think it has been a learning experience to me. I certainly didn't know anything technical, and I especially, since I was convinced that we could still have a hybrid conference for a long time until the variants taught me that I was wrong. Okay, we could not meet like that. So anyway, Virginia, thank you very much, and I look forward to meeting you next year.
Exactly.
In Salerno.
Sure.
And this time, I hope, not with saved by vaccines, but saved by the fact that the unfortunate situations that we are facing should simply have improved significantly, right?
Yes, exactly. And Laura, and that's really, once again, I mean, thanks to you, really by the deep of my heart, but I think that I am interpreting the feeling of everyone who took part in this conference. You were the North Star of this conference, as you have always been the North Star of this of the conference that haven't taken place during the year. And it's beautiful, a beautiful way to talk about environmental integrity, to just compare different experience and take into account what's important, the importance of doing, of discussing each other, of focusing on this topic, and maybe let people know that another world is possible. If we talk to each other, if we talk to politicians, if we try to change the way we live, because at the end of this is my opinion, you know, there is little doubt that humanity has caused profound changes to the Earth's climate and land uses since the middle of the 20th century. But however, and unfortunately, we currently do not have the capacity to stop these changes. But what do we have is the possibility to talk, you know, to spread the consciousness that another world is possible. Only what I have to do is just stop. You know, I find to stop thinking that progress means, you know, what we have seen, but the world, how it is now. Progress is not that. Progress is.
Thank you very, very much, Virginia. And I know that there would have been a lot of responses to Rose's presentation, particularly by Katie, who disagrees about it. But then again, well, that's what it's all about, these conferences, having all different approaches and suggestions. So let's hope we can meet in
Salerno, yes.
Next year.
Yes.
Thank you all very much for participating. And again, I am sorry for my kind of morbid introduction to begin with, but when you come kind of close to death, beyond COVID, that's the way you feel. Anyway, all of that is over for now. The hospital has cleared me. They gave me the next appointment 6 months from now, in December. So I think things are going reasonably well. Thank you all again for coming and for all you've taught me. And Katie, I will be in touch with you very shortly so that we can start figuring out how to put together the number of participants to submit to Brigitte Reschke. Okay?
Perfect.
No, Laura, a big hug to everybody. A big hug.
Big hug, virtual hug, and next year in person.
Exactly. Exactly.
I look forward to that. I want to be hugged, and I hope I can travel because I don't do vaccines. You see, I don't believe in vaccines.
No, don't worry. I will ask for you a special permission.
Okay, thank you so much, dear. I'm going to hang up now and leave you all to have fun together if you still want to. Thank
yes,
you.
of course,
Thank you.
Of course.
Thank you.
Bye, Laura.
Bye,
Thank you,
bye.
Laura.
Thanks,
Bye,
Laura.
Bye.
Cheers.
Ciao.
All right, Jeff, movement forward, or should we end on that note?
Well, I think what's been said has been said. Just, you know, remember, if you haven't sent in your short summary or abstract, Laura is really counting on that to make decisions about papers. So please do that. If you haven't, I also put a note in about the bulletin board. I'm going to have all of the
I have
chats.
all the PDFs. Everybody has pretty much a finished page PDF, so I'm good.
Okay, great.
I'll go downstairs and I disconnect everything for me.
No, yes, of course.
See you next year. God willing. God willing.
And I mean, really a special thanks to Jeff, because you really, yes, okay. Because you really faced this very hard time, and I mean, to organize a meeting in this way, you know, is great. It really is great.
Well, thanks to you all. I think we're all, our heads are abuzz with a lot of new ideas, and that's what we come together for every year. We'll continue the discussion.
Sure.
From here, and you know, in between the meeting and again next year when we get together. Thank you all
Katie,
so much.
A big kiss to you.
Yeah.
Joseph, ciao. I miss you a lot.
We miss you. So good for this reunion. Thank you, everyone, from my heart.
Ciao, everybody. Next
we'll see you next year.
And I'm gonna close off the video.
Ciao, Pavel. Ciao, Pavel.
No, I'm hearing you, but for me it's better not to look at very much. But bye bye.
Bye, Christian. Look at Klaus and Christian.
Hi guys, it was a true pleasure. I hope to see you in person next year.
Thanks, Giada, and everybody who moderated too. Yeah.
Onwards to Salerno.
Yep. Good job. Good
Indeed.
job, everybody.
All right, bye-bye.
Bye-bye.
Bye.
Bye-bye.
Bye-bye.